14, 1-4. 1-4, Lordship.
1-4, same order.
Like you, Lordship.
Lordship, I have prayer for taking two unlisted motion matters, Lordship. Bail petition, Lordship.
At 2.
Lordship, Lordship.
May I please, Your Lordship. May I please to mention item number 6. Your Lordship, let the matter come up after 3 weeks, Your Lordship. I have a concern.
Ms. Livika, London Government Council, who prays for listing this matter after 2 weeks,
3 weeks, Your
3
Lordship.
weeks. She also submits that she has obtained the consent of London Council for the petitioner. Hence, the prayer is allowed. Let this matter be listed after 3
weeks.
weeks.
Your Lordship, I also beg to mention item 9. Your Lordship, here I'm yet to receive instruction on the newly implemented respondent, Your Lordship. So another 3 weeks, Your Lordship.
No objection.
Okay, no objection.
Heard Ms. Livika, London Government Council, who submits that she has to receive instructions from newly pleaded respondent. And on that ground, prays for an adjournment for today. Learned Counsel for the petitioner does not object to the said prayer, hence the prayer is allowed. Let this matter be listed after 3 weeks.
Much obliged, much obliged.
My lord, please allow me to mention item number 25.
Yes.
Yes. As per the court order, I have served the notice to trustee. And I may be allowed a 1 week time to file a affidavit on completion of service report to trustee.
Heard, Mr.
And for the petitioner.
What is your name?
Pakin Richabo.
Pakinri Chabo, Learned Counsel for the petitioner, who prays that he has taken steps for service of notice on the respondent. This is a bail application.
Lord, yes, my lord.
Proxometry is there.
We, the court directed to implement DRI, Directorate of Review Intelligence.
Okay.
After serving a notice to registered AD.
Okay. Learned Counsel for the petitioner submits that he has taken steps for service of notice on the newly pleaded respondent through Dasti service and prays for 1 week time for filing affidavit regarding the service of notice through Dasti mode. The prayer is allowed. Let this matter be listed after a week. Also heard Mr. V. Zimumi, Learned Public Prosecutor.
Lordship, I beg to mention item 21, Lordship.
31.
21. Lordship, here the state respondent is yet to file counter affidavit, Lordship. So, Lordship, may please grant 2 weeks time. If this matter can come up after vacation.
My lord, in IA, I am the petitioner, and through this IA, I'm seeking a prayer in intervention of this honorable court. My village council, our village council has been dissolved, and the entire GB has been suspended. And now, as per the provision of the Nagaland Village Council Act, Section 3 and 4 emphasize that there should be a village council. But for last more than 1 year, there is no village council, and the villagers are now facing so many difficulties to cope up with the situation. So, as a petitioner, I filed in IA in the main case against seeking the intervention and prayer of this honorable court to at least constitute an interim village council. Otherwise, we could
Let them respond on that.
Lordship,
my lord,
there is a caretaker, Lordship, as of now.
caretaker registered, no doubt.
The
But how long the
head
caretaker will carry on?
Lordship, in that
There is
way,
an interim provision in the act also.
Yes,
When the council is dissolved,
Lordship,
who is
section
to act?
22, Lordship. Yes, Lordship.
But
let
Lordship,
them respond to your
my
interim
lord, they
application.
are taking enough time.
Lordship,
have taken
after the vacation, so that
Respond to the IA at least,
Lordship.
the interlocutory application.
Yes.
You file,
Lordship, if that can come up, since we are filing our affidavit, Lordship, in the course.
okay, let it come up
Lordship,
together.
Lordship.
Heard,
So in the-
heard Mr. Bedang Wabam, Learned Counsel for the petitioner. Also heard Mr. V. Zumami, Learned Government Counsel. who prays for some more time for filing affidavit in
Lordship,
opposition
Lordship.
in, as well as objection in the interlocutory application. Considering the submissions made by the parties, the prayer is allowed. Let this matter be listed after
Vacation, Lord.
4 weeks.
Lord. Hello.
Please, your lordship. Your lordship, I'd like to mention hearing item 41 to 49, your lordship. These are analogous matters. This matter may be listed after 2 weeks, your lordship.
You are for,
For the state respondents, your lordship.
what is your name?
In a holy, your lordship.
Miss Ina Holly, London Government Council. Prays for listing these matters after 4 weeks.
3 weeks.
After 3 weeks, Learned Counsel for the petitioner does not object to the said prayer. You have any objection?
No, your lordship.
Does not object to the said prayer, hence the prayer is allowed. Let these matters be listed after 3 weeks.
Much obliged, your lordship.
May I please, lordship. I'd like to mention from hearing item number 30. My lord, I pray that this matter may be listed after a week, my lord. 30. 30.
30 and 31.
Item number 30, 50,
Item number
50, 50.
50.
Well, I'm for the petitioner.
Heard Mr. N. Lon Kumar. Learned Counsel for the petitioner who prays for listing this matter after 3 weeks.
After a week, my lord.
After a week, the prayer is allowed. Let this matter be listed after a week.
My lord, I have a similar prayer for item number 5 also, my lord. I pray that this matter may be listed next week, my lord. Item number 5.
5, same order.
And my lord, item number 7, I have instructions to appear for the respondent number 3.
5,
Yes,
who is
5
appearing for government?
for
Mr. Angami,
Yes, for the state I'm.
show his presence. Heard Mr. N. Angami, Learned Senior Government Counsel, appears for the state respondent. You don't have an objection to his?
No,
Okay. Let this matter be listed after we.
My lord, I also like to mention item number 7. Here I have instructions to appear for the private respondent number 3. So I'll be filing my power in the course of the day. So I may be given 2 weeks time to file my necessary affidavit. my lord.
Heard Mr. N. Longkumer, who submits that he has instructions to appear on behalf of private respondent number 3. And he shall be filing his wakalatnama during the course of the day. And on that ground prays for an adjournment for 2 weeks. You have informed the appellants.
Yes,
He submits that he has informed Learned Counsel for the appellants regarding his prayer. The prayer is therefore allowed.
Your
Let this
Lordship, I may be allowed to the liberty to file counter on the amendment.
Miss V.
No. Renboni, for respondent 1 and 2.
Miss Renboni, Learned Counsel for respondent number 1 and 2, submits that she needs some time to file. This is an appeal. In appeal, you will be filing,
Yes, Your Lordship.
want to file counter,
Yes, your lordship.
file an objection. She is allowed, the prayer is allowed. Let this matter be listed after 2 weeks.
my lord, I also would like to mention item number 16. Here I'm appearing for the respondent number 2. So I pray that I may be given 2 weeks time to file my necessary objection and
Who is for the petitioner?
uh,
Heard Miss Renboni, Learned Counsel for the petitioner. Also heard Miss N. Longkumar appearing for respondent number 2
Lordship, I'll be appearing for respondent number 1.
and Mr. N. Angami, Learned Senior Government Counsel appearing for respondent number 1. Mr. N. Longkumar prays for 2 weeks' time for filing his objection to the
To
petition.
file necessary affidavit.
Filing the affidavit in opposition. The prayer is allowed. Let this matter be listed after 2 weeks.
Much obliged.
May I please, my lord? Lordship, I beg to mention item number 11. Here I am appearing for respondent number one, and the other respondents are represented by additional GV Shokre. If 3 weeks time can be granted to us, your lordship, to get receive the necessary instruction, your lordship.
Yes.
Objection, your lordship. No objection.
What's your name? Benison.
Benison V. Choi.
Heard Mr. Benison Vishoy, learned counsel for the petitioner. Also heard Mr. N. Angami appearing for respondent number one. Ms. V. Sokre, learned additional AG appears for other respondents.
Lordship.
Mr. Angami, learned senior government counsel, prays for 3 weeks time for filing.
To receive the
to
necessary instruction from the
receive the
respondent.
necessary instructions from the respondents. The petitioner does not, learned counsel for the petitioner does not opposes the said prayer, hence the prayer is allowed. Let this matter be listed after 3 weeks. 3 weeks.
Deeply obliged, my lord.
Please, your lordship. I beg to mention item number 22. Notice is yet to be completed. So I believe this matter will be listed after 2 weeks.
You are for,
I'm for the petitioner.
heard Mr. Benison V. Shoy, learned counsel for the petitioner. You will have to, we have to await notice service report,
Yes,
Yes,
yes, your
yes.
lordship.
who submits that the service report on the respondents are still awaited. Also heard Mr. N. Angami, learned counsel for the
Respondent number one.
respondent number one. Stop. In view of submission of the counsel for the parties, as the service report is awaited, let this matter be listed after 2 weeks.
No. Deeply obliged, my lord.
Your lordship, I also beg to mention item number 51. I believe this matter may be listed after 2 weeks.
Heard Mr. Benison V. Soy, learned counsel for the writ petitioner, who prays for an adjournment for 2 weeks. The, who is appearing for government? Mr. T. P. Tiba form
My lord, I'm appearing on behalf of Subung Chang.
appears on behalf of Supumla Chand, learned government counsel, and does not oppose this said prayer. The prayer is allowed. Let this matter be listed after 2 weeks.
May I please, lordship? My lord, I beg to mention hearing item number 30, 31, and 32. Here, I'm yet to file counter, my lord, in the affidavit in reply filed by the petitioner. So kindly allow me 3 weeks time, my lord.
Heard Mr. P. T.
E. Thibaut.
E. Tiba form, learned counsel for the petitioner,
Given
learned counsel
from
for
all
the,
petitioners.
learned counsel for the, learned government counsel, learned senior government counsel, who
Government-
sorry, learned government counsel, who prays for some more time for filing affidavit in opposition.
Yes.
Also heard Miss Vikono Kiso, learned counsel for the petitioner, who does not oppose the said prayer, hence the prayer is allowed. Let this matter be listed. These matters be listed after 2 weeks,
After 3 weeks,
after 3 weeks.
much obliged. Again, my lord, I beg to mention item number 52. Here, I'm yet to receive instruction. So kindly allow me 2 weeks time, my lord. By order dated 12/9/2023, the state was directed to produce the abar of the petitioner. And accordingly, I have informed the respondent, but I'm yet to receive, my lord.
Heard Mr. E.
Lordship, I have objection.
Oh.
Lordship, on 12/9/23, direction was issued to produce the hour of the petitioner. Because Lordship, the promotion of the respondent
Direction, what direction was issued?
to produce the service book of the petitioner.
Service book.
Yes.
Okay.
Now, Lordship, the challenge made in the writ petition is that the respondent who is new to the petitioner has been recommended and promoted to the higher boss on consideration of the abars
On consideration
of
of,
the service records of both the petitioners and the respondents. Now, the question is, Lordship, without communicating the remarks, readings of the ACR, whether the recommendation of the TBC can start. Because law is very clear, Lordship. As per the principle laid down in the Debtat case reported in 2008, every clearings entry in the service should be communicated to the person concerned before recommending for permission, which is not been done in. the present
No,
case.
by 12th of September, the direction was
I
to
don't know
produce.
what is the difficulties. to produce
The direction was to produce the service book.
The upper report,
It is from Commissioner Office. Kohima,
What
Lordship.
report?
upper annual performance assessment
In
report.
other words, it's a service board. Lordship.
Okay.
And
So may I bring the Lordship, matter will be listed on 17th next Tuesday for disposal, because my junior is holding the higher post.
Is it possible for,
my lord, it won't be possible, at least 2 weeks, my lord.
let them give 10 days. Because that document would be required unless they produce that.
Lordship, even without the reports of this case can be disposed of, Lordship.
But there is a
The law is very
direction,
clear.
direction.
In that case, Lordship, a
Let
date
us-
may be fixed, a date may be fixed.
Yes. Mr. E.T. Buffon, London Government Council submits that prays for some more time for producing the service book of the petitioner as directed by order dated 12/9/2023. Mr. Watizami prays for some objects to the said prayer, submitting that on last occasion, that is on 12/9/23, the state respondent was specifically directed to produce the said service book today itself. However, considering the submissions made by London Government Council, one more chance is given to the the respondent side to produce the service book of the petitioner.
My lord, not the service book, it is the upper,
I am not getting an A,
APAR, annual performance assessment report,
A,
PAR,
V, A, annual.
performance assessment
Okay,
report.
okay. Annual performance in
Assessment.
place of service book mention, annual performance assessment
Assessment
report
report, yes.
within bracket
Yeah.
APAR.
Yes, ma'am.
The state respondent is directed to produce the annual performance assessment report of the petitioner on the next date fixed, that is on
31st.
31st of October,
Yes.
31st October 2023.
Much obliged.
Your Lordship, I'd like to mention item number 33. Kindly this matter will be listed after Puja vacation.
Mr.
I am Chair, Your Lordship.
I Im Chen, learned counsel for the appellant. Who is for the, also heard Miss Esther, sorry, Viket Sono, learned counsel for the respondent, learned counsel for the appellant prays for an adjournment which is not objected to by the counsel for the respondent, hence prayer is allowed. Let this matter be listed after 4 weeks.
Much obliged, Mr. Lordship.
May it please, my lord. Lordship, I may be allowed to make a mention for hearing item 34. If it can kindly come up after 2 weeks, my lord. Hearing item 34.
Heard Mr. Senti Younger, learned counsel for the petitioner who prays for an adjournment which is not objected to by Mr. K.V. Angami, learned government counsel. Hence the prayer is allowed. Let this matter be listed after 2 weeks.
Obliged, my lord. Lordship, I also make a mention for hearing item 35. The next item.
35.
Yes, my lord, if my lord will be willing to take it up on the next Thursday. Depends on my lord's convenience.
If it reaches on that day, we may fix it, but it
My lord,
whether it
My lord,
If time permits, we'll take it up.
my lord, my lord.
On request of learned counsel for both the sides, let this matter be listed again on 19th of October 2023.
Deeply obliged, my lord.
May it please your lordship. Lordship, I'd like to mention item number 27, lordship, for orders. Lordship, in this matter, we have instruction to appear on behalf of OP respondent 1, 2, and 3, lordship. So we'll be filing Baglanama next week, lordship,
Next week,
for 1, 2, and 3.
No, please, lordship. Lordship, here, I'm for the appellant, lordship. Lordship, as per the office note, the return service report is still awaited, lordship. So,
service report on
return service report, lordship, upon respondent number 4.
respondent number 4 is awaited.
Oh, yes, lordship. So kindly grant us to file a substitute notice, lordship, through paper publication,
Okay.
where a respondent resides. lordship.
What is your name? I forgot.
Empty Wapang, lordship.
Heard Mr. Imti Wapang, learned counsel who submits that he has instructions to appear on behalf of respondent number 1, 2, and 3, and and he will be filing his wakalatnama
Next week,
in the
lordship.
next week,
Lordship.
and hence prays for a time for the same. The prayer is allowed. On the other hand, Mr. M. Vero, learned counsel for the appellant, submits that the service report on respondent number 4 is yet awaited,
Yes.
and he prays for allowing the appellant to take steps for issuance of notice on the respondent number 4 through substituted mode of paper publication
Yes, lordship.
in a local
Respondent resides, lordship.
local newspaper where the respondent number 4 resides.
Yes, lordship.
The prayer is allowed. The appellant shall take steps for issuance of notice through paper publication
In 6 days, lordship.
within 6 days from now. Fixing a fixed date has to be given. Fixing 6th of November,
Lordship.
6th of November
Lordship.
for return of the notice. Let this matter be listed again on 6th of November.
Obliged, lordship.
Well, please, lordship. Lordship, I again beg to mention item number 24, lordship.
24,
Yes, lordship. On behalf of the leading counsel for the petitioner.
heard Mr. M. Vero, learned counsel for the petitioner who prays for an adjournment due to non-availability of the conducting counsel for the petitioner. Also heard Mr. K.V. Angami, learned government counsel, learned government advocate who does not oppose this said prayer, hence the prayer is allowed. Let this matter be listed after 2 weeks.
Lordship, kindly let the matter be fixed, lordship, on 20 November, lordship.
Let this matter be fixed on 20th of November.
Lordship. Obliged, my lordship.
May it please the lordship. Lordship, I beg to mention item number 20, lordship. Lordship, here I'm appearing for the petitioners. Lordship, here we're challenging the seniority list of veterinary doctors, lordship, and there is a stay. However, lordship, we were informed that one of the respondents, he was promoted, even though there is a stay order, lordship. So if I may be given 2 weeks time to file an affidavit to bring that on record, lordship.
Heard Miss
Lucino, lordship.
Miss
Lucino,
Lucino, learned counsel for the petitioner,
petitioner in the
who submits
petition.
that in spite of having a stay in the matter, one of these respondent has been promoted
lordship,
during the pendency of this
lordship.
proceeding. And she prays for leave of this court to bring the said matter on record by filing an affidavit.
Lordship,
The prayer is allowed.
lordship.
And how much time would be?
2 weeks, lordship.
She prays for 2 weeks' time for the same.
Lordship,
Also heard Mr. E. Tiba form,
Yes,
learned
I'm appearing for respondent number 1 to 4.
senior government counsel, learned government counsel who is appearing for respondent number 1 to 4.
Yes. 1, 2, 3, and 4.
1, 2, 3, and 4. The matter may accordingly be listed after 2 weeks.
And in the meantime, Lordship, if the interim may,
The interim
Extended.
order shall continue till next day.
much obliged.
Much obliged.
May I please, Lordship? Lordship, I beg to mention item number 23 on behalf of BKK. As per the office note, the return service report is still awaited upon respondent number 2. So kindly fix the matter on 31st of October.
Heard Mr.
Our semi, Lordship.
R.
Semi.
R. Semi, learned counsel for the appellant who submits that the service report is still awaited as regards respondent number 2. Also heard Mr. V. Zimomi. Await service report. Let this matter be listed
31st of October.
on 31st of October.
Much obliged.
Please, Lordship. Lordship, I also beg to mention item number 18 and 19, Lordship, on behalf of Mr. T.B. Jamir for the petitioner, Lordship. Lordship, if this matter can come up after the puja break, Lordship.
Heard Ms. Lucino, who submits on behalf of Mr. T.B. Jamir and prays for an adjournment. Also heard Mr. Foseco Forte and Ms. Desino Kizo, appearing for Learned Central Government Standing Council, who does not oppose the prayer of the petitioner. Hence, the prayer is allowed. Let this matter be listed after
Puja break.
3 weeks.
Lordship, I'm for respondent 5,
Mr. Foseco Forte appearing for respondent number 5.
EPC. Lordship, your Lordship, I'm led by Mr. Dr. Todi, Ankit Todi from Gauhati, Lordship.
You
if
want a
Lordship
fixed
can-
date?
Lordship, yes, Lordship. The matter can come up on 4th of December, Lordship.
Is it okay for you?
Lordship.
4th
Let
December.
the matter be listed on 4th of December.
Very much. Lordship, I beg to mention item 53, Lordship. 53, I'm for the petitioner. 53,
53.
the last item, Lordship. Lordship, my senior some difficulties, Lordship, if the matter come up after 2 weeks, Lordship.
Heard Mr. Foseco Forte. You have informed counsel for the
Yes,
respondent
Lordship.
who submits that due to personal difficulty of his senior, he prays for an adjournment for 2 weeks. He also submits that he has informed learned counsel for the respondent. Considering the submissions made by the learned counsel, the prayer is allowed. Let this matter be listed after 3 weeks.
Lordship. Vice Madam.
Please, Lordship. Lordship, I beg to mention item 36 to 39. I have instructions to appear on behalf of the respondents and I'm here to file Vakalatnama. Kindly grant 4 weeks time to file Vakalatnama.
Heard Miss
Alito Su.
Anito
Su.
who submits that she has the instructions to appear for the respondent and prays for some time for filing
4 weeks time.
4 weeks time for filing Vakalatnama. Also heard Mr. Foseco Forte, learned counsel for the appellant who does not oppose the said prayer. Hence the prayer is allowed. Let this matter be listed after 4 weeks.
Vice Madam.
Please, Your Lordship, I beg to mention hearing item number 40.
40 has already been mentioned.
40.
Or 40 is not.
40.
Yes.
Your Lordship, I am praying for 2 weeks time.
Lordship, if this matter will be fixed on 6th of November. 6th of November.
Heard Mr. Im Song, learned Central Government Standing Council, who prays for adjournment of for 4 weeks. Also heard Miss VK Son, learned counsel for the petitioner who prays for listing this matter on
6th of November.
6th of November, to which Mr. Im Song does not opposes. Hence, let this matter be listed on 6th of November.
Lordship, I beg to mention item number 3, item number 4. Your Lordship, here is a contempt matter and by the last order, that is 26 September 2023, the respondent has given a last chance. But Your Lordship, here, with your apology, I need some more time. Because Your Lordship, here, this contempt, it involves two communities. So since 2019, we have been trying to comply the order of the Honorable Court. But because it's a very sensitive involving two communities, so we have spent a lot of time. And again, the Honorable Court also is patient enough to wait for such a long period. But Your Lordship, now the matter is coming to an end. So unless
Matter is coming to,
end, we are going to comply.
okay.
So unless the last chance is given to.
Last chance was given in
Yes.
the last
So
occasion.
many last chance we have received.
So many last chances have
So,
been given. Lordship.
When real last chance will come?
Lordship, 39 households have been displaced, Lordship, since the year 2008, Lordship. And the government, they have been citing one tribe, one of the tribes.
You're appealing
Lordship-
for state respondent
Yes,
or as CGSC,
state responsible.
state respondent.
Lordship, I pray that some time may be granted to you, but in the meantime, if personal appearance may be called for, Lordship, because there is already an order, Lordship, if your Lordship may.
No, if you don't
Kindly-
comply with by next date,
Yeah,
then you have to appear
yeah,
personally.
I'm for another last chance.
No last chance.
Last chance, of course, Your Lordship, the Honorable Court was kind enough. But the thing is, on our part also, since it is involving two communities, it's a very sensitive case.
Heard Mr. Imti Song, London Council, London additional AG
For respondent one and two.
for respondent number 1 and 2. Who submits that though the state respondent was granted last chance on earlier occasion to comply with the order of this court. However, considering the fact that the matter is sensitive and involves two communities. He prays for some more time for complying with the order of this court. On the other hand, Ms. Lucino, London Counsel for the petitioner, submits that the state has been given sufficient indulgence. State respondent have been given sufficient indulgence. And though she does not oppose to grant of time for one more occasion, she submits that on failure to comply with the order of this court, the state respondent may be directed to appear personally. Considering the submissions made by learned counsel for the parties, one more chance is given to the,
State
I'm
respondent.
not using the word last because one more chance is given to the government, state
State
respondent to comply with the order of this court as prayed for. Let this matter be listed.
After 2 weeks,
Lordship, if a date may be fixed, Lordship.
You choose a date.
Lordship, let it come up on the 6th of November, Lordship.
Let this matter be listed again on 6th of November.
oh, Marshal.
For motion, item number 1.
Wait, please, Lordship.
Yes. Yes, Mr. Jamil.
Lordship, this instant application is arising out of the anticipatory bail application number 29 of 2023, Lordship. The anticipatory bail application, which was disposed of, Lordship, by this honorable court on the 24th of August 2023, Lordship. Direction was given to the petitioner, Lordship, to appear before the investigating agency within a period of 1 week, Lordship. Now, this IA, it has been filed, Lordship, with a prayer for extension of time, Lordship, a month's time, Lordship. What has happened, Lordship? When the main petition was heard, Lordship, the state represented by the PP, yes, pardon record, Lordship, 2 orders, non-bailable arrest, warrant of arrest, Lordship, issued by the learned court of CGM Dimapur, Lordship. It was issued on 17th of July 2023, and the subsequent is on 1st of August 2023. Lordship, the petitioner was under tag, Lordship. I was not aware of this orders, Lordship. Now, after disposing that main application, Lordship, I'm filing this IA, Lordship. On the stand of this too, I'm apprehending arrest, Lordship. Already 2 orders were issued by the CGM, Lordship.
No, anticipatory bail was granted with regard to which case?
The same case, Lordship. It is arising out of the
Before
same
the
case.
Court of Chief Judicial Magistrate.
Yes, Lordship.
Lordship, they have moved the,
It is a charge sheeted case.
no,
No, Lordship, no, not yet, Lordship.
During pendency of the investigation,
Lordship.
and CGM has issued non-bailable warrant of arrest.
Yes, Lordship.
In,
On 2 occasions, Lordship.
on the prayer of police.
Yes, Lordship.
Okay, okay.
And I was not aware of those orders, Lordship. So the 13th of 2023, Lordship.
Okay,
I have categorically stated about the difficulties, Lordship.
okay.
And that
Then
has
it
also
was extended.
Yes, Lordship, it was
Okay,
extended,
okay,
Lordship. And Lordship, after extended the time, Lordship, meantime, what has happened, Lordship, I came to know about the existence of these 2 orders, Lordship. And there is also an criminal petition, which is listed in item number 13, Lordship. There's a criminal petition. I'm also challenging to quash and set aside the 2 orders, Lordship, for issuing of non-bailable warrant of arrest, Lordship, on the ground that no summons were issued, Lordship. The court, the London trial court, should have issued summons, Lordship, in the first place.
No, they have, court has issued bailable warrant on the prayer of police.
Lordship.
So question of, it is not a charge sheeted case.
no.
Question of summons does not arrive. If you would have complied with the summons, police would have issued you notice under 41A.
If your Lordship may kindly appreciate, Lordship. I have also stated in my read petition, the criminal petition as well as the earlier anticipatory bail application, Lordship. I have also replied on 3 occasions, Lordship.
Now, what is the prayer in this application?
2 prayers, Lordship, for extension of a month's time. Second is, if I may be allowed to appear to BC, Lordship. I'm a resident of Gauhati, Lordship.
No, this second is a totally different, which was not granted. Mr. Zimomi, what is your submission?
Yes, Lordship. Lordship may kindly come to the petition, IA petition. More particularly, relevant portion, page 9, Lordship. This is the order passed by this honorable court on 24/8/2023, Lordship. The relevant portion, last paragraph, starting from last paragraph, if I may allow to read, Lordship.
Yes.
Mr. V. Jimomi Leonard, PP for the state of Nagaland, placed the detailed report for the from the investigating officer in connection with the Dimapur PS case number 43/2023, referring to the detailed case report. Learned PP submits that the offense under section 406 and 420 has been clearly made out. Moreover, importantly, despite several notices issued under section 41A of the CRPC, the appellant is intentionally evading Lordship. That is one. And if Lordship may kindly come to last paragraph, having considered the material available on record and in view of the submissions of the learned counsel for the appellant, that the accused appellant is suffering from various ailments, including cardiac problem. This is the submission advanced by the applicant. This court is inclined to grant the privilege of pre-arrest bail to the applicant Sri Ajay Bahadur Singh with the condition that the appellant accused shall appear before the investigating officer in connection with the Dimapur PS case number so within a period of 10 days from the date of this order and cooperate with the investigating officer on such appearance in the event of his arrest in connection with Dimapur so the applicant shall be released on bail of rupees 40,000 with one surety of like amount. The satisfaction of the arresting authority. It is made clear that very important Lordship, it is made clear that if the appellant accused fails to appear as directed herein above, the bail granted to the accused shall automatically stand cancelled, Lordship. That was the last. And Lordship, from this Lordship, the protection was given to the applicant.
Before lapse of 10 days, have you applied for extension?
No.
That
Lordship.
interim application by which the extension was given.
No, Lordship, this is the said application is after the initial order was passed for extension of 10 days, Lordship.
This is for the first time you are appearing for extension.
This is the second, Lordship. Earlier, by filing an IA-13, Lordship.
When
And moreover, Lordship,
Yes.
in the IA Lordship, no explanation has been given as to why the applicant failed to appear before the investigating agency, Lordship. So, Lordship, from the conduct of the accused, Lordship, it appears that the applicant is trying to evade from the investigating agency, Lordship. And moreover, Lordship, they have not complied with the course of the Lordship. When the protection has
where
already
is
been
the
granted to
extension order?
applicant.
Lordship, it is not part of the record in my IA, Lordship. However, the limited crown I'm seeking before this honorable court.
No,
by filing
the
IA,
extension which was granted earlier.
Lordship.
No.
There was no
the order,
No, let me understand.
Lordship.
The anticipatory bail application was allowed by order dated 24/8/23,
Yes, Lordship.
whereby you were directed to appear within 10 days.
Lordship.
Thereafter, you did not appear,
No.
approached,
No.
and you filed an interlocutory application.
Lordship, yes.
Whether that was allowed,
No.
or this is for the first time you are appearing.
Lordship, this is the first time. This is the first
There
time.
is no in between, there is no.
13 has not been disposed, Lordship. I have filed in IA, Lordship, that was not been disposed, Lordship.
Then
So-
why have you filed this one again?
Lordship, this.
What happened to 13? IA 13?
IA-13, Lordship, the prayer was not allowed, Lordship.
Oh, it was rejected.
Yes, Lordship.
Okay, but you are not submitting that.
Lordship, this IA has been filed, Lordship. After the reports were placed before the Honorable Court at the time of hearing of the anticipated bail application, Lordship. Now, this two orders, 17 July and 1st of August, Lordship. These two orders were brought before the court, this Honorable Court, Lordship, by way of when the reports were submitted, Lordship. And I was not aware of this non-bailable warrant of arrest issued by the.
No,
by the trial
now
court,
the
Lordship.
question is, when your IA was rejected, and when you have not appeared before the within the stipulated time,
Lordship.
then it has lapsed.
Lordship.
Then something which has lapsed, whether can we extend that?
Lordship,
You make me understand. If we can do it, we will do it.
this
Because
honorable
by
court-
operation of this court, that has lapsed.
Lordship,
The court was very categorical while passing that order
Lordship,
on 28th. That if you fail to,
if your lordship may kindly allow me to turn to the orders, lordship. Page 12, lordship. Annexure 2, lordship. Page 12, annexure 2.
then there cannot be an extension. It has to be revived. Or it has to be a fresh bail petition. Otherwise, court's order would not mean anything. Because court's order was very specific.
Lordship.
So unless there is a prayer for revival of the, or a fresh anticipatory bail application, it cannot be extended.
Lordship.
It has already lapsed.
Lordship, I agree, lordship. However, if I may be allowed to read this order, lordship, the main contention, lordship, and the allegations made in the by the complainant, lordship, in the FIR, lordship. This case, lordship, it is the
No, we are
complainant,
not hearing it any further.
lordship.
You may make submission at 2.
Lordship.
By that time, I intend to dismiss it. And why should not, I should not dismiss it, you have to satisfy.
Lordship, lordship,
So we'll take it up at 2.
lordship.
By that time, if you can satisfy that why, because my understanding is something which has been lapsed,
Lordship,
cannot be extended.
lordship,
You make me understand otherwise
lordship,
at 2.
lordship.
For motion, item number 2.
May I please, my lords? I hope I'm audible to my lords.
Yes.
So, my lords, this is a matter arising out of a summoning order dated 17th May 2023. Now, my lords, in this matter, my lords, this is a classic textbook example of a malicious prosecution, my lords. The complainant is a resident of Delhi, my lords. I will show from the document his own affidavit, my lords. And my lords, the accused persons proposed to be tried for 138 pilots. They are also residents of Delhi and Pune, Maharashtra. Now, my lords, the fact of the matter in this case is, now, my lords, on way the 4 checks were stolen out of some business. So we were in business relationship, my lords. Now he was acting as one of my partner in the business. Now, my lords, I have lodged a complaint way back before even the check was presented.
How many petitioners are there?
3 petitioners, my lords. One is a partnership concerned, my lords.
Okay.
Number 2 is Major Vikas Chiller, my lords, one of the partner. And number 3 is, my lords, Miss Sonam Singh, who is also wife of Major Vikas Chiller, my lords. And she is mother for 2 infant children, my lords. Now, my lords, the only thing which my lords needs to see on the law, on the pure law point, my lords, I'm well conscious that I have to satisfy my lords on the law point. Now, my lords, may kindly see the list of documents which is annexed with the complaint, that is at page 73 of the paper book.
Yes.
Now, my lords, may kindly see item number 5, serial number 5. Original speed post receipt dated 3/3/2023 along with its tracking report. Now, my lords, this is a list of documents from the complaint. Now, my lords, may kindly come to page 87. And my lords, page 82 rather, my lords, I'm so sorry. Page 82 is the true typed copy of the evidence by way of affidavit on behalf of complainant.
Yes.
So, my lords, may kindly see I. Kumar Rajesh, he is the complainant, my lords, son of so-and-so, aged so-and-so, residents of so-and-so, apartment sector 14, extension Rohini, New Delhi, 110085. Now, my lords, may kindly see page in this evidence affidavit, page 87, paragraph 14.
Yes.
Now, my lords, I will just read the last three lines. A copy of the legal notice dated 2/3/2023 is exhibited at Exhibit CW1/3, and the original postal receipt dated 3/3/2023 is exhibited as Exhibit CW1/4. Now, my lords, there is no tracking report. Now, my lords, what the complainant says in the complaint itself with regards to my address, that the address was incorrect and therefore the legal notice was not served. This is an admitted position, my lords, and I will beseech my lords in this reference to kindly refer to section 138B and C, my lords.
No, why are you saying that legal notice was not served?
Is, my lords, may kindly see this para 14 itself, page 87. I will read, my lords, what it said. I state that my proprietorship through its counsel issued a statutory legal notice dated 2nd March 2023, which was sent on 3/3/2023 by speed post and WhatsApp. There is no proof of WhatsApp, my lords. I take a pause. Thereby calling upon the accused person to pay it should be pay, my lords, the aforesaid check within 15 days from issuance of the aforesaid notice, which were duly received by the accused persons. However, despite mentioning the last known address of the accused person in the above said legal notice, the same was returned on account of address being inaccurate. It is pertinent to mention that even after my best endeavor, the current address of accused person could not be traced. Now, my lords, in this reference, what the paradoxical statement, now, my lords, I need to, if my lords may kindly come to page 98. Now, there has been legal notices being exchanged between the parties. My lords may see page 98.
Yes.
Now, my lords may kindly see the address at 2 and 3, my lords. The address of 2, Major Vikas Chiller, shows of, now, my lords may kindly take note of it, this. Partner Pal, so flat number A702, Annex Society, Magarapatta City, Pune. And then for Mrs. Sonam Singh, wife of Major Vikas Chiller, retired partner so-and-so, A20 Sai Apartment, Sector 13, Rohini, opposite DD Club, New Delhi. So, now, my lords, the Rohini address would demonstrate, my lords, that the both complainant and one of the accused has a permanent residence of Rohini in New Delhi. Now, my lords, may kindly see that first check which the complainant has presented in Delhi, that is at page 145. Now, there were 4 checks. So first check was presented in New Delhi. And then, my lords, that check, since I have given instructions for a stop payment, so, my lords, it got bounced and the complainant sent me a legal notice that is at page 145.
Okay.
That is at page 145, notice dated 20th January 2023. Now, my lords, may kindly see the address.
Yes.
So, my lords, may kindly see address for 1, 2, and 3. Same address.
Same address.
Yes, my lords. Now, my lords, may kindly see page 149, para 10 of this legal notice.
which is issued by the counsel of the complainant in New Delhi. Para 10 minutes at the bottom at page 149.
Yes.
On 29/12/2022, our client, believing that above mentioned check would be honored on its presentation for encashment, presented check number so and so, dated so and so, for rupees 50 lakh through its banker, Yes Bank Limited, 387 Rohini 2. Now, my lords, I take a pause. This Rohini 2 is New Delhi. Now, my lords, may kindly see my reply to this legal notice. That is at page 152.
Yes.
Now, this is being addressed to the lawyer Billets, Indresh Upadhyay and Associates. Now, my lords, with these all factual, undisputed factual matrix, my lords, 2-3 things surfaces for my lord's consideration. One, my lords, this gentleman, the complainant, has nothing to do in Nagaland, in Parain, nothing, my lords, just for the purpose of intimidating and harassing, my lords. Now, what he has done, that he has gone to Parain, he has opened a bank account, my lords, and he has got the check dishonored, my lords. The second check, first check was presented in New Delhi, my lords, pursuant to which this legal notice was issued. I replied, my lords, no complaint was filed before the territorial limits of Delhi courts. No complaint, my lords. Now, my lords, what happened? That since I have responded, and I will show, my lords, I have earlier police complaints much before even this legal notice was served upon me, and the checks were presented. Now, what went, my lords, that he, in order to intimidate me, goes to Parain, open a State Bank of India bank account, presents my check, issues a purported legal notice which was never served upon me, my lords. The legal notice, the list of document as filed before the learned trial court, I have shown to my lords that at serial number 5, it says tracking report. I have shown to my lords the evidence by way of affidavit. It does not exhibit the tracking report, my lords, meaning thereby that that legal notice was never ever sent, much less being received by me. Now, my lords, in this background, only on the pure question of law, my lords, I will refer and I will beseech my lords to kindly see to subsection B of section 138.
Enact. Section
138, subsection B, my lords.
Yes.
The payee or the holder.
Albert, I want enact. Negotiable instrument. Yes, you may read.
Yes, my lords. So I will read, my lords, subsection B. The payee or the holder, in due course of the check, as the case may be, makes a demand for payment of the said amount of money by giving a notice in writing to the drawer of check within 30 days of the receipt of information by him from the bank regarding the return of the check as unpaid. And C, the drawer of such check fails to make payment of said amount of money to the payee, or as the case may be, to the holder in due course of check within 15 days of receipt of the said notice. Now, my lords, the substratum, my lords, is precisely the legislative intent, my lords, and the catena of judgment, my lords. The offense under section 138, in my respectful submission, would not be deemed to be committed, my lords, unless the defaulter, the purported defaulter has received the notice, and after 15 days from receipt of the legal notice, he has failed to make the payment. Even in 15 days, my lords, my respectful submission, that even if I receive a notice today, so I have 15 days, my lords. If in 15 days I pay, no offense is committed, my lords. The offense under 138 would only be deemed to be committed after 15 days. Now, my lords, in this background, my respectful submission for my lord's consideration is this, my lords. In the present case, I have demonstrated before this honorable court 2 points, my lords, purely on one law point, my lords, that notice was never served. There has been deliberate concealment, my lords, before the learned trial court. The list of document, my lords, at serial number 5 says that tracking report has been filed. I have shown to the my lords the evidence by way of affidavit. Only the purported speed post receipt has been exhibited. Had the tracking report, which the complainant had mentioned at item number 5 of the list of document, would have been exhibited, my lords, the trial court would have applied its mind, because I have all reasons to believe, my lords, and I say with all due conviction at my end, that this was purposely done. A notice would have been sent to some other address so that at some day, my lords, I am being maliciously prosecuted. Now, my lords, I have shown to my lords with regards to the notices exchanged earlier with regards to factum of my address, apart from the address being mentioning before this honorable court on affidavit, I have shown the document from the complainant itself that he has served the legal notice on the same address. There is no document exhibited before the learned trial court which could demonstrate that whether this notice has been served over email or even WhatsApp, my lords. Although my WhatsApp and email numbers are there and it is appearing in the first legal notice which has been sent. These documents are not exhibited. Now, my lords, in this background, with all my great respect, my lords, I only beseech this honorable court, my lords, considering that one person is a retired major of Indian Army, my lords, and considering that the second person is, my lords, mother for 2 infant children, my lords. So, my lords, this proceedings, my lords, it stands vitiated.
Your submission is what I understand. Main submission is that the notice under 138B has not been served on you.
Yes, my lords. That is an admitted position from the averment contained in the evidence by way of affidavit. I have just shown to my lords.
Then what is there in the tracking report has not been exhibited, no?
No, my lords. The list of documents mentions it at serial number 5.
And the deponent is himself saying that even after best of endeavors, current address of the accused person could not be traced out.
My lords.
So whether notice was deemed to be served?
No, my lords. It will not be deemed to be served in my respectful submission, my lords. And my lords, I have also shown to my lords with regards to earlier round of notices being exchanged between the parties on the same address. I receive a notice from very same address, and I also reply to that, my lords.
And you are still residing in the same address?
Yes, my lords. Yes, my lords.
Okay.
Now, my lords, in this background, if only, my lords, to persuade, my lords may kindly see that even before the first check was presented in
otherwise jurisdiction of the parent court is there, because the law says that wherever you present the check, wherever it got bounced, that court has the jurisdiction.
Yes, my lords, but
on that you don't have any other submission.
In this regard, my lords, apart from my first limb of submissions, which my lords are appreciating, the second limb is, my lords, that this honorable court, being a constitutional court, is, my lords, has to see that whether only for the purpose of harassing or intimidating someone, my lords, can, just because misusing the proposition of law, a person travels from New Delhi to Parain, my lords, open a bank account, even does not give any local address in Parain, not a whisper in the complaint as to what the complainant is doing in Parain, whether he is engaged in some job, some employment, some business, no whisper, my lords. So this honorable court, being a constitutional court, is not bereft of the power, in my respectful submission, to correct such wrongdoings, my lords, which is being purposely done for initiating a malicious prosecution. That's my respectful submission.
Otherwise, the complainant is also resident of Delhi.
Yes, my lords. I have shown from the affidavit, my lords.
So now we don't know from your petition under what circumstances the check was presented at Parain.
No, my lords.
There may be some circumstances under which it has to be presented before Parain.
So, my lords, my submission in this regard is, my lords, just for
to harass you.
Yes, my lords. Because, my lords, when the first check was presented in New Delhi, I have shown the legal notice in Yes Bank, my lords. And when the check returned unpaid, he sent me a notice. I replied back to that notice. And there is a history to that, my lords. I'm not troubling my lords with regards to earlier police complaint. Even this gentleman has forcefully entered into my house at Pune, my lords. I have filed a police complaint even much before.
Okay, heard Mr. Sharif Ahmed, learned counsel for the,
So, my lords, my name is Farooq Khan. I'm sorry.
Your name is not mentioned in,
My lords, I have my Wakalatnama, my lords. I'm on my Lucino is my local counsel, my lords. I think she is there before the honorable court.
heard Mr. Farooq Khan, learned counsel for the. You are a senior advocate.
No, my lords, no, my lords, not yet, my lords.
Heard Mr. Farooq Khan, learned counsel for the petitioner. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed by the petitioners, namely Messrs. Partha Project number 1, number 2, Major Vikas Chillar and Ms. Sonam Singh, praying for quashing the proceedings of complaint case number 2/2023 filed under section 138 of the Negotiable Instruments Act 1881, which is pending before the Court of Learned Chief Judicial Magistrate Peren, Nagaland. Learned counsel for the petitioner submits that you had business transaction with the respondent,
Yes, my lords, in Delhi.
that the respondent is a proprietorship firm which is situated at Delhi, at Rohini, Delhi, and the present petitioners are also from Delhi, and they had business transaction amongst them. That 4 stolen checks, who has?
No, my lords, I alleges, my lords, I have filed a police complaint in that matter.
You have filed.
Yes, my lords, at page 127, I have filed a police complaint.
And how these check regarding which the 138 case has been filed in Peren is one of those checks.
Yes, my lords. Yes, my lords.
Learned counsel for the petitioner has submitted that the present petitioner at page 130.
Page 127. That is my police complaint, my lords, 38/2022.
That on 38/2022. Who lodged this complaint?
No, my lords, this complaint was lodged.
The petitioner number 3.
Yes, my lords.
Sonam Singh lodged an FIR before the officer in charge of Sector 14, officer in charge of police station at Sector 14, Gurugram, alleging theft of where is that check?
Para 7 may kindly be seen, my lords, page 130.
You have not mentioned the numbers, no?
No, my lords, because at that time, my lords, it is
Theft.
much
Okay,
before.
theft of certain checks of the complainant's firm, certain blank and signed checks of the complainant firm. It is further submitted by learned counsel for the petitioner that as regards one of those checks, which was alleged to have been stolen in the said FIR, the present petitioners have lost the instant complaint case in the Court of Chief Judicial Magistrate Peren, alleging dishonor of the said check only to said check. Stop. Learned counsel for the petitioner has submitted that though the petitioner as well as the respondents are both residents of Delhi and their business transactions are also at Delhi, and with regards to other checks, other checks out of those 4 stolen, one as regards other check that had
One check, my lords. That is
One
at page
check.
145.
which was presented in Delhi.
Yes, my lords. Page 145.
Yes, Bank,
Yes, my lords, page 145.
one
And-
of the check of the said stolen checks was presented in the Yes Bank at
387 Rohini 2.
at 387 Rohini 2, which the petitioner had instructed not to. You had issued some instructions.
Top checks, my lords.
Petitioner has issued stop check. Where is that instructions?
Yes, my lords. No, my lords, I will show my reply to the legal notice. That is at page 152. Now, pilots may kindly say, if my lords may kindly see page 158.
Yes.
My lords, para 18, my lords, I have given the background. And then, my lords, I say that apart from this check, which we have presented a stolen check, you are also called upon not to present any other check, my lords.
What was the last name? Yes, Bank. Stop check instruction, stop disbursement instructions. However, learned counsel for the petitioner submits that only to harass the present petitioner, the respondent without having any business transaction at parent have presented at parent which check has been presented, you know the number? Presented one of the check which was alleged to have been stolen at a bank. Which bank? Which bank? You are not audible.
Sorry, my lords, it is a State Bank of India at page 92 is the return memo.
At the State Bank of India, page
Dimapur.
After opening a fresh account in that bank, only with an intention to harass the present petitioner, so as to make him to travel to parent court. It is presented at Dimapur or parent?
Parent, my lords, if my lords may kindly see, the return memo at page 92, which is annexed with the complaint. Return memo report, my lords. It is a part of the complaint. State Bank of India presenting branch name Dimapur.
But Dimapur and Peren are differently located places.
It may be a case, my lords, that the clearing center of a State Bank Dimapur branch.
Because your NI cases can be filed only in that
Yes, my lords.
jurisdiction where the bank is situated.
Yes, my lords. So my submission is this, my lords, that the bank account would be in Peren. This would be a clearing branch, my lords, some zonal
Right.
office type of setup.
So bank account is in Peren, na?
Yes, my lords.
Stop. Learned counsel for the petitioner has also submitted that page 87. That from the evidence on affidavit of the respondent which was filed as complainant in CR case number 2/2023 before the Court of Chief Judicial Magistrate, Dimapur. No, this case is pending not at parent.
It is in parent, my lords.
It must be in Dimapur. We have to check what court in Dimapur. But this evidence on affidavit is in before the court at Dimapur.
Yes, my lords, but my counsel has appeared in parent, my lords. Even the bailable warrant has been issued now by the parent court after filing of this petition before this honorable court.
So this has, Ms. Lucino, where the case is pending? Is it in parent or because the evidence on affidavit which you have referred to is.
If my lords may kindly see the summoning order, if my lords may kindly see page 48. That's a true type copy of the summoning order. District Parent Court of Chief Judicial Magistrate present order and then dated 17/5/2023. That is an impugned order before my lords today.
This is in case number?
Case number, my lord, CR2, if my lords may kindly see at the top at right, my lord, CR2/2023 at page 48, my lords.
But the evidence on affidavit which you are referring to has been filed in the court of CJM Dimapur, not in parent.
So, my lords, this is something, my lords, which when the respondent comes to this honorable court can explain, my lords, because these document I have taken from the parent court itself, my lords. And if my lords may kindly see the complaint also, I will show the evidence affidavit which my lord was seeing at page 82.
No, page 8, I am referring to page 82 only.
Yes, my lords, Dimapur and then CR case number 2 of 2023. So, my lords,
But CR case number 2 of 23 may be there in Dimapur also, in parent also.
no, my lords, but I say on instructions, my lords, that only one case is pending and that is the parent court as of now.
But the documents which you have placed before this court.
Yes, my lords.
Shows that this evidence of affidavit is of a different case pending before a different court.
So, my lords, I am only, my lords, concerned today. I only beseech the honorable court's attention to this parent order, my lords. So, my lords, only thing with regards.
No, unless I take into consideration your evidence on affidavit.
My lords.
It shows that notices are not served.
My lords.
The stay may not be granted at this stage. Then we
So,
have.
lords, I will show from the complaint, my lords, if my lords may see the complaint also. With regards to this particular fact which has been said in this evidence affidavit.
Where?
My lords may kindly see page 68. Now, my lords may kindly see the opening pages of the complaint. It has page 63. And then at page 68, my lords, para 17.
63 also refers to Dimapur court.
Yes, my lord. So that might be a problem, my lords, that they would have mentioned Dimapur there and the court has taken the cognizance, my lords.
No, but unless I am clear about that, I can issue only notice.
So my lords may only protect from coercive action, my lords. Not to stay the proceeding, my lords. I will confirm this, my lords, because bailable warrant has now issued.
No, for that you have to seek separate protection. Now I'll be issuing, because of this mess up of two courts, I am issuing notices only.
So, my lords, in that event, my lords may only give me liberty of 2-3 days, my lords. I will go personally verify everything and will come to this court, my lords, again. So, my lords, my lords, seriously, there is a problem, my lords. The bailable warrants have now been issued. And that's why I have prayed for an interim relief, my lords.
I will not grant interim relief until I am satisfied. Because you are showing affidavit of a different court, different case, seeking stay in a different case. The case locations of this you have to make me understand.
So, my lords, my only respectful submission would be in this count, my lords. I can only say, my lords, today that this is the pleading, my lords. If my lords may kindly relate the check number and, my lords, the complaint, if my lords will juxtapose it, my lords, it will be clear that this is the check number where which this summoning order has been issued by Parane Court, my lords. Now, why, my lords, this is being Dimapur mentioned in the heading, in the nomenclature, my lords, of course, my lords, as of now, my lords,
you seek instructions. There is an option if you, otherwise I'll issue only notice.
So, my lords, my clients are here only before this honorable court, and my instructions are, my lords, that it is the same matter.
No,
I can,
only your instructions would not do. Something you
so,
have to show.
so, my lords, a statement of my lords in under instructions may kindly be recorded, and my lords may please to protect. And my lords, if I have said something wrong on affidavit, my lords, I will face the music, my lords.
No, still that is not convincing, because the documents which you have referred to does not.
If I may show only two things, if this could, I'm able to convince the honorable court with regards to the check, my lords, the check in question, where which this this summoning order has been issued. If I may,
Mr. Farooq,
I'm sorry, my lords.
what I would suggest, you go through the things, make it clear, let it be fixed after 2 days.
My lords,
Check
I
number
can do.
mentioned in another order dated.
If my lords may kindly see,
We will file it.
Not in hurry.
I have just gone.
You take your time.
My lords, will do, my lords.
I'll fix it again.
So, my lords, may kindly give me 3 days, my lords, because
Okay.
somebody has to travel from Delhi to Parane, my lords.
No, otherwise also you can seek instructions without traveling. There are modes.
Will do, my lords.
You have to only find out whether the affidavit, whether the case is pending at Dimapur or Parane, whether the affidavits you are referring to pertains to Dimapur case or Parane court. That is the only confusion.
Will do, my lords. What I will do, my lords, that I will apply a certified copy of the entire this matter before the Parane court.
When do you want it?
So, my lords may only give me like 4 or 5 days, my lords, maximum.
Mr.
Farooq Khan, FRRRUKH.
Mr. Farooq Khan, learned counsel for the petitioner, who submits that for seeking some clarifications regarding the pleadings made in this case, he needs some time, which is hereby allowed. Let this matter be listed again on. When do you want?
My lords, may keep it on Monday or Tuesday, my lords. Tuesday, my lords, subject to my lord's convenience.
Okay. Sixteen.
So, my lords may also permit me to appear by VC, my lords, on next date also, my lords.
Tuesday, 17th. Let it be on 17th at 2 p.m. through video conferencing.
I'm so grateful, my lords. Deeply obliged, my lords. So grateful. Deeply grateful, my lords.
Earlier part goes.
For motion, item number 3.
If this matter may also be taken up together, two lodge.
Okay. Otherwise, we can issue notice in this
Lodge.
instead of
Lodge,
heard
can-
Mr. Moaz Amir, learned counsel for the petitioner. Also heard Ms. V. Zimumi, learned public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner praying for quashing of the order dated 17/7/2023 and order dated 1/8/2023 passed by learned. Who has passed this order?
CGM Dimapur Lordship.
Passed by learned Chief Judicial Magistrate Dimapur in connection with Suburban Police Station Dimapur PS case number 43/2023 under section 420/406 of Indian Penal Code corresponding to GR case number 471/2023, whereby non-bailable warrant of arrest was issued against the present petitioner. Issue notice to the respondents. And case diary would be required. And call for the case diary of Suburban Police Station case. Police Station Dimapur PS case number 43/23. As Mr. V. Zumomi learned public prosecutor appears for the respondent number 1, no formal notices need to be issued to respondent number 1. However, as regards respondent number 2, the petitioner shall take steps for issuance of notice to the respondent number 2 by registered post with AD from returnable within 3 days from date of this order, returnable after 3 weeks. Or you want a fixed date?
After 3 weeks. Lordship.
After 3 weeks.
Much better.
For admission, item number 8.
I'm assailing a charge sheet and also an order passed by the learned James, whereby my further investigation was directed. And whereas, my lord, though I've not specifically mentioned the pleadings, my lord, there is a compromise between the informant and the accused, informant who is also victim, and my lord, that was a part of my lord's the charge sheet that is brought into record, my lord, by an additional affidavit. And my lords, I have also taken drastic steps whereby my lord, the informant had received, but she has not appeared, my lords. And whereas, my lord, that
Case relates to?
case relates to my lords, there is a
What is the offense?
offense is my lords 506, 509 IPC and 67A of
Okay,
the IT Act, my lords.
okay.
Now, these two informant and victim, my lord, they are cousin sisters. There was some misunderstanding and there was some circulation of some
Informant has not appeared,
appeared, my lord,
but service is complete.
service is complete. And that apart, my lord,
There is an order regarding
my lords, yes, there's an order.
completion of service.
Yes.
Okay,
And I have brought on record, my lord, there's an additional affidavit filed by me. Whereas, my lord, that there's a compromise, my lord. That compromise was also a part of charge sheet. So my lord, I'll implore the
part
lordship.
of charge sheet.
Yes, it is a part of charge sheet, but I brought it on record, my lord. So record by an additional affidavit, my lord. The matter was settled between them. The my lord takes up the additional charge, this additional affidavit. Additional affidavit was founded.
Yes.
I will see they are my lord, they are cousins and they in their vernacular, it's written in vernacular, it's translated in the page number 5, that they have settled the case and decided to bury the hatchet and not to pursue it anymore. Rusty affidavit was also filed.
Which section is non-compoundable section?
Well, it's 67. 67 A IT Act, my lord. It's offense specific related to, my lord, female. When a cyber crime is committed against a female, my lord, it's non-compoundable. And that's the reason I'm before lord. And that apart, my lord, if my lord takes my main petition, my lord. My main petition, page number 22. Learned trial court, my lord.
Mr. Angami,
Yes, he has also no objection.
can it be disposed of?
Lordship, as far as there are two accused, Lordship. As far as she's the first accused, now there's the second accused, as per the charge sheet. Now, as far as the first accused is concerned, if Lordship is comfortable, I prefer a liberal approach in this. The only technical difficulties in the prayer, nothing is mentioned that they are seeking question of the FR.
As regards the second accused.
No, even the first accused, no prayer is made on the basis for question on the basis of the compromise or the police.
What is the prayer?
My initial prayer and first and foremost prayer was to quash the impugn order passed by the learned court below.
What
And
was the order?
And this is an order of the JMFC dated 4/2/21. And only on the course of hearing, my lords, when I pointed out that there was in fact, my learned senior also helped me out, that there is a compromise which is a part of the agreement, which is a part of the charge sheet, my lord. So in only on that premises, my lord,
No, you are challenging only the order relating to
Order-
further
my lord,
investigation.
Charge sheet also impugned, my lord. Charge sheet is also impugned. Cost title, my lord.
No, what is the prayer?
Charge sheet, my lord. Charge sheet has set aside a charge sheet. And also the implement. Because when the charge sheet is the foundation, if the charge sheet goes, my lord, everything goes.
And as far as the impugn order of the JMS is concerned, he has no case, Lordship.
He has
No case, Lord.
no case.
No case. Because there's a Supreme Court ruling, which is the order clearly reflects at page 22.
Okay, let us hear it. You are ready for final?
I'm ready, my lord.
You are also ready.
Yes, Lordship.
Okay.
Page 22 of the petition, my lord. Charge sheet was laid. I admit, my lord, initially, my lord, there was no whisper about this compromise. Page 22, my lord, see. It starts from the word bearing in mind. Lordship has got it.
Yes.
Bearing in mind the nature of offense, alleged the investigating officer ought to have conducted a more thorough investigation.
Page 22.
Page 22.
There are para 38 is there.
No. It's starting, my lord. Start. When it starts.
First line.
Yes, first line, my lord. First line, bearing in mind.
Yes.
If I may read it.
Yes.
Bearing in mind the nature of offense alleged, the investigating officer ought to have conducted a more thorough investigation into the offenses alleged. Full stop, my lord. Even, my lord. Even hypothetically, if we were assume that this court proceed on negligence available today, there will be no evidence agreement that the bearing in trying or trying only in excellent and fidelity.
Okay.
Magistrate has, my lord, learned magistrate court below has considered everything. And my lord, he has come to a conclusion that even if we proceed in these materials, my lord, this trial will end, it go nowhere. And as regards the Supreme Court, my lord.
That is as regards the charge sheet,
Yes.
which is before the court.
My lord.
Okay.
My lord, Page 23, madam. The learned court below has resorted to justify his direction by citing a Supreme Court decision. My lord, see the decision, page 23. It's, my lord, it's quoted verbatim. There are, my lords, there are certain lines which are underlined.
Yes.
Yes, my lord, it would be. But my lord, the same judgment says, where it, my lord, the line ends, my lord, if, for example, fresh facts come to light.
Which would lead to
My
income.
lord.
Read it.
Yes, my lord.
What you want to submit?
I want to submit, my lords, that in this charge sheet, my lord, there was nothing.
Okay.
He had come to a conclusion, and my defense has been exposed, my lord. And my lord, no fresh facts were brought to light. And a magistrate has to proceed, my lord, only on the provisions under.
Now, what this cite ruling which has been cited by, what it says, you may tell me.
It says, my lord, a magistrate can order further investigation if the investigating officer, my lord, if he comes with fresh facts, But in this case, my lord, will see the earlier lines which I had, my lord, tried to point out that in this case, hypothetically, if he proceeds, my lord, there is nothing. It exposes the, my lord, the conviction that he is bound to give conviction, but whereas, my lord, there is no materials out there. And in the apart from that, my lord, this is a legal proposition. Apart from that, my lord, since I'll take lordships to page 60 of the petition.
Page 16.
16.
Yes.
Page 16, madam, see enclosures. Enclosures, madam, see a handwritten, madam, agreement bond 1 numbers. My lord has got it.
Enclosures number which
8, my lord.
handwritten agreement bond.
Agreement, my lord. This is the agreement which is, my lord, is annexed at the additional affidavit.
Whether the record is before us, no?
Record was called for, my lord.
Okay.
My lord, I am relying on a few citations, not too much.
No, now what you want to say that
My lord, I have 2 grounds assailing this, my lord. One is, my lord, the charge sheet is my lord, charge sheet doesn't
is not sufficient.
not sufficient.
The magistrate himself has made
Has direct, because my lord, he can order further investigation. I respect that his power, he has a power, I admit that. But when only fresh facts come to light, there was no fresh facts placed, my lord. Nothing was filed before the magistrate. And also, my lord, will see.
And when the further investigation was directed, the agreement was there before the
Yes,
court.
my lord, that is the point, my lord. Charge sheet I have shown, my lord. Charge sheet, it was the charge sheet, the agreement bond was
So
there, my
your
lord.
submission is that in light of that agreement, further investigation ought not to have been.
Yes, also, my lord, that since there was no materials, the magistrate has himself admitted that hypothetically, if he proceeds, these are 2 limbs of my submission. My lord, I rely on a Supreme Court judgment. In fact, what is very recent, my lord, of 2022? It's Kapil Gupta, offense was 376. This is my lord, that one, Kapil Gupta, my lord. 29.7 is there. 29.7.
Paragraph
29.7. While deciding whether to exercise its power under 482 of the code or not, timings of settlement play a crucial role. Those cases where the settlements arise immediately after the alleged commission of offense and the matters still investigation, the High Court may be liberal in accepting the settlement required with proceedings / investigation. It is because of the reason that at this stage the agency is still on the unit charge has not been filed. Likewise, those cases where charges state that evidence is yet to start, or the evidence is still at infancy stage, the High Court will show benevolence in exercising the power of favorability. But after the time of this assessment of the circumstances made, said material mentioned about. On the other hand, when the prosecution evidence was complete or after completing the evidence that matter, so the state argument normally the High Court should refrain from exercising the power of the in some cases the trial court with this permission to cite the case finding merit and to come to a conclusion as to whether the offense under 307 and under 307. 307 is committed or criminal case was convicted is already recorded. But where charges to or 307 are convicted, there is no question paragraph complete found guilty of subject crime. Another paragraph 30. Next paragraph. It thus can be seen that this court has clearly held that no court should be slow in passing the proceeding where in areas in serious crime involved. The High Court is not focused for examining as to whether there exist materials for interpretation of such an offense or as to whether there is sufficient evidence to prove and would lead to provide proving the charge for the offense charged with. The court has also taken consequence to whether settlement between the parties going to result in a harmful system which will improve the mutual relationship. The court next the court has further held that it is also relevant to consider what is the state of proceeding. It has been observed that an application may have been state, but if the evidence has been led and the matters itself a stage of arguments or judgment, the court is slow to exercise its power to pass the proceeding. However, such applications made an initial stage before the commencement of trial. The said factor will weigh with the court in exercising its power. And the facts and circumstances, as stated herein above, are peculiar in the present case. Respondent number 2 is a young lady of 23 years. She feels that going to trial in one case where she is a complainant, in another case where she is accused, would drop the prime of her youth. She feels that if she is made to face the trial, rather than getting in relief, she will be faced with agony and undergoing the trial. In both the 16 months, in both the cases, though the charge sheets had been filed, the charges are yet to be framed, and as such, the trial has not commenced. It is further to be noted that since Respondent 2 herself
But in this case, charge sheet has been filed.
yes, ma'am. This has been taken care of, madam. Para 16 minutes. In married, yes. In both the cases, though the charge.
Which para you are reading all paragraphs?
16, madam.
Which are you relying?
I rely on 16.
Okay.
16. And also, my lord, this 29.3 up portion of that.
No, read 16. Read 16.
16, madam. In both the cases, though the charge sheets have been filed, the charges are yet to be framed, and as such, a trial has not yet commenced.
Therefore, as regards stage of quashing, it supports you.
I'm coming to that. I'm coming to
that. At this stage also it can be
it
quashed.
can be quashed, madam. Charge sheet has been filed, madam. The trial has not commenced. It is further to be noted since the respondent number 2 herself is not supporting the prosecution case. Even if the criminal trial is permitted to go ahead, it will end nothing else in an acquittal. If the request of the parties is denied, it will be amounting to only adding one more criminal case to the already overburdened criminal courts. 7, my lord. In that view, the matter we find though in a heinous or serious kind like rape, my lord. This was rape, my lord. In my matter is not about rape. The court should not normally exercise the power of passing the proceedings in a peculiar facts of the present case. But in order to give succor to Respondent 2, so she was safe of further accused, we find that this is a fit case when extraordinary powers of this court should be exercised to quash the criminal proceedings.
So further, I like to take
Copy of this.
no, I'd like to do a break.
Oh, yes. For 2 minutes, I'm taking.
If you recover, I was not in the. But this is what it is. Otherwise, it's on the bottom. Yes.
Yes.
We may resume. My lord, I'm also relying, my lord, this Supreme Court, my lord, 2018-15 SSC.
SCC page.
It's 343.
Yes, what it says. Para?
There are 7 to 12, my lord, very short judgment, my lord. This was an offense under, my lord, 394. And it was also not covered by 320 of CRPC, compounded, or not compounding. Number 7, my lord. The aforesaid question has troubled this court on different occasions, not only in connection with compounding offences punishable under the criminal justice system, but also in respect of civil matters and in respect of material matters in particular, wherein the court has to strike a balance between the legitimacy of
In
law.
this case, the objection of learned public prosecutor is as regards your prayer for quashing of the order for further investigation.
No, my lord.
Yes.
Yes.
That is your main.
Yes,
That is-
because
As
that-
regards charge sheet, you don't have much to say. As
yes,
regard,
but the lordship, the thing is in the pleadings, they have not come on the basis of questioning the FR on compromise. So the petition is defective. That is my concern. Otherwise, if they could come that on the basis of compromise and putting aside the impugn order, I think things would be more easier for the court as well as for the prosecution. But just like this is,
In fact, if my lord
though with how much you want to help out the cases, I think technical difficulty is there. And as far as the order is concerned, now my learned friend has not highlighted everything, but the judge, the learned below said that the investigation seems to be not sufficient to present the case. So go further in this investigation.
but composition, that matter has been compounded, has been brought on record by additional affidavit. But they have not prayed for
Yes, that is,
compounding
yes,
the quashing on that ground.
yes, that is my concern.
if I admit to that, but my lord, it is this honorable court which pointed out, if my lord sees the orders passed, and this is the honorable court which has pointed out, since you have compounded, bring it on record. We can look into it. Well, this is the honorable court's query, my lord. This was not my case. It was further developed into that.
Lordship, everyone is trying to help.
Yes, but if my lord, the charge sheet goes, well, everything goes.
No, but for going off charge sheet also.
This is 482, my lord.
That is the ground that you should come with
My lord, we
proper
are under
pleadings.
482, my lord, 482.
Though court's power is there,
Yes,
but you have to come that that you are praying for quashing on the ground of
non-availability of any evidence, my lords, and then the minister cannot direct. This
But-
was my two contentions.
But your now main grounds appear to be.
No,
a-
my lord, I can satisfy lordship on other ground also.
Okay,
Also,
okay.
that also I can satisfy. This
So-
is one of the grounds. So I said, my lord, when I started, my lord, there are two grounds. Initially, I had only one ground,
There is an order of this court
my lord.
observing that,
Yes, this
regarding
we did not record.
okay.
So my lord, that judgment, para 11. my lords. 9, 10, 9, my lord, in the case on hand, the petitioner is convicted for the offence punishable under section 394 and is sentenced to 2 years rigorous imprisonment. We are aware that the said offence is not compoundable within the scope of 320 CRPC. 10, my lord, in a series of decisions, so and so, my lord, many has been quoted, this court allowed the parties to compound the offence, even though the offence is not compoundable, depending on the facts and circumstances of each case. In some if the court while imposing the fine, reduce the sentences to the we did already undergone. What emerged from the above is that if an offence is not compoundable within the scope section 320 at the of the CRPC, the court will give the compromise arrived at the party reduce the sentence imposed while maintaining the conviction. Here, my lord,
This is after conviction.
my lord, this is after conviction. Well, I'll also my lord, this Rajan Gauhati judgment of our honorable court. Where there was a charge of 376. Passed by my lord, honorable Justice Suman Syam. This here, my lord, FI was under challenge.
Yes. Which para you are?
My lord, paragraphs are not numbered. My lord, will go to page 4. Page 4, lordship is correct.
Yes.
In case of pervert by Ahir and means in by Karnoor and others reported in church, the honorable concluding this paragraph at the minor bottom line.
Yes.
The Honorable Supreme Court has held heinous crimes of rape, murder, equity cannot be compounded, therefore such proceedings cannot be quashed by invoking the jurisdiction under 482. But at the same time, it has also been noted clearly that the scope and ambit of the power of the High Court to quash any proceeding in excess jurisdiction under 482 of CRPC has been firmly settled since the decision of Apex Court in the case of Bhajan Lala. In the present case, the allegations mentioned that even if taken as a face value, the opinion doesn't consider the offense or make out a case against the petitioner under 3, this is rape, 376, rather allegations brought in could at best make out a case in 417 and 506. Section 320 of the CRPC lays down the offenses which are compoundable, and offense under 417 is compoundable by the person cheated, and offense under 506 is compoundable by the person cheated. In this case, mother the victim and the husband have sworn affidavits denying the occurrence of the material or record of the compromise by and between the parties. There is no order verifying to conduct in further investigation in the matter. Therefore, having regard to the material written record after conclusion of the court of view that there is no chance of conviction of the petition in this case under such circumstances denying the legal state for the petitioner would amount to the question of whether resulting in a single case carried for justice. Here, my lord, I'll pause for a moment. Here, my lord, FR was submitted, but my lord, the learned court, my lord, magistrate, my lord, he rejected the FIR, and my lord, he ordered further investigation. As reason stated above, I have the unhesitating opinion that applying the ratio laid down by the Supreme Court and General, the present is the fit case for the court to invoke jurisdiction under 42 CRPC, and orders it is so and so I'll consider and part accordingly set aside. I'll take the lordship to
The orders of further investigation.
yes, my lord.
Were
They were
also
quashed because agreement was my lord there. Lordship, I'll come to page number 2, my lords. Page number 2. The first initial paragraph, my lord, is everything. Not opinions are taken, my lord. This civil petition. This explains the premises of this petition. This civil petition has been filed with the proceedings under PRC number pending in the court of law, CJ now, that is an order rejecting the FIR. Submitted by the previous subsequent order, taking taking cognizance of the 417, 376, I investigate the petition. This is the premises of this order.
Okay.
And there, you can see the magistrate, my learned magistrate, while passing the order, has taken recourse to 173, 156, 173, subsection 8. This is the other limit.
Now, in Rajan Gohain's case also 173.8 was involved. No, in this case which you have cited, whether 173.8 was involved, no.
But cognizance was taken, it was quashed. My entire.
But you are not regard.
I am on the other part of judgment wherein my lord that agreement, my lord, that the agreement between the
Basis for.
yes, my lord, that was
basis
one of
for
the condition for quashing. So my lord, this learned magistrate, my lord, at page 23 of the petition has taken recourse to 173 subsection E. Magistrate can very well, my lord, he can go for further review, he can direct further investigation, but there are certain stipulated conditions. CRPC 170, it says 173.8 says, my lord, if my lord takes a CRPC.
What are those conditions?
Nothing in this section shall be deemed to take to further investigations in respect of an offence. After a report of the subsequent forwarded to the magistrate, where the officer in charge of the police obtains further evidence, oral or documentary, he shall forward to the magistrate further report or reports regarding such evidence in the form prescribed. The IO has to come and say that I have received such information. There is a requirement for further investigation. Herein, my lord, herein, my lord, he said this IO respectfully, my lord, IO has not said like this. And my lord, this conviction mind of the magistrate has been exposed at those lines, but that even he posed.
No, read it again. Where are the grounds where further evidence?
Yes, my lord, nothing in the section shall be deemed to preclude further investigation in respect of office after report and subsection to and forwarded to the magistrate, and where such investigation the officer in charge of the office of police station obtains further evidence. There's no further evidence.
No. You are reading wrongly. That is, if further evidence is taken recourse to, and during such further evidence, if he obtains,
yes,
that it's purport, not what you are saying.
Look,
on what grounds
yes,
further evidence may be directed, that is not mentioned there.
He has to, police officer has to give a report that I have found.
That is after further evidence.
Yes, no. After the report, but shall not deemed to take, shall be deemed to take, nothing is deemed to take to further investigation of it after a report. Here, there is no
only that much.
There is no report.
No, report is the charge sheet is the report.
In my assumption, I may be wrong. I maybe
if I may suggest, I think if they really need relief to help everybody, I think they should come with a fresh petition. I think on the basis of that agreement.
One matter of 21, and my lords, I have other citations also, my lord. When two different views are there, my lord. When the two different views are there, I have already, my lord, at page 22, I point out the magistrate says, my lord, there is no material. There is no material to proceed. Even if we proceed, it will end in futility, my lord. And when, my lord, two views are possible, lordship knows very well that two views are possible. The view which supports the accused, my lord, that view must be taken into account.
Not always.
Not always, my lord. But here,
yes, Mr. Angami, do you have any submission? Any other submission? Your main ground is that observation of the magistrate that charge sheet is not sufficient to proceed with the
No, no.
trial.
I'll-
The
I'll-
magi- Then he directs further
Yes. I rely on a 2008 10 SCC 394. This is Yogesh. Yogesh alias Sachin Joshi versus State of Maharashtra.
what it says,
Specifically, my lord, it says in paragraph 60, it's right. It's right. It's right that the words not sufficient ground for proceeding against the accused appearing in the section postulate exercise of judicial mind on the part of the judge to facts of the case in order to determine whether a case for trial has been made out by the prosecution. However, in assessing this fact, the judge has the power to shift and weigh the material.
no,
Material.
this relates to framing of charges on this
Well,
case.
I'll just conclude that paragraph, my lord, since that find out my framing of charge, my lord, but if two views are equally possible, the judge is satisfied that evidence produced before him gives rise to suspicion only, then and always distinguished from a grave stage, he is not to see as to whether the trial will end in conviction or not. The broad test applied is for materials on record, if unrebutted, make a conviction result impossible. That is my count.
Yes, Mr. Ankam. Regarding charge sheet, there is an observation by the magistrate that materials are not sufficient. We will go into it that whether materials are, that observation is okay or not. If we go by observation of the magistrate, then charge sheet does not have any force, is not sufficient to proceed with. That observation has already been given by the magistrate in the impugn order. And regarding the power to direct further investigation, because his prayer is twofold, for quashing of the charge sheet as well as quashing of the impugn order. Now, what are your submissions?
Lordship, I'll just rely on the judgment of the magistrate, Lordship. There's no infirmity. If you look at the order passed, page 22.
Yes.
22, last sentence. The first paragraph, the last sentence, the second last sentence.
Yes.
If I may, Lordship, the Honorable Supreme Court, in the case of Haribai, Binubai, Malavia, and others versus State of Gujarat and others, had allowed the magistrate enough exercise discretion to direct further investigation post the stage of cognizance until the trial commences in a case. For the sake of convenience, the irrelevant paragraph of the case is here being reproduced. There is no good reason given by the court in this decision as to why a magistrate powers to order further investigation will suddenly cease upon process being issued, and an accused appearing for the magistrate while concomitantly the power of the police to further investigate the offense continues till the stage the trial commences for him. Such a view would not accord with the earlier judgment of this court, in particular Sakiri Supra, Samach Parivartan, Samu Daya Supra, Vinay Tyagi Supra, and Hardeep Singh Supra, having clearly held that a criminal trial does not begin after cognizance is taken, but only after charges are framed. What is not given any importance at all in the recent judgment of this court is Article 21 of the Constitution, and the fact that the article demands no less than a fair and just investigation. To say that a fair and a just investigation would lead to the conclusion that the police retain the power, subject, of course, to the magistrate's note under Section 173(8) to further investigate an offense till charges are framed. but that the supervisory jurisdiction of the magistrate suddenly ceases midway through the pre-trial proceedings would amount to a travesty of justice, as certain cases may cry out for further investigation so that an innocent person is not wrongly arraigned as an accused, or that a prima facie guilty person is not so left out. There is no warrant for such a narrow and restrictive view of the power of the magistrate, particularly when such powers are traceable to section 156+3, rather with section 156+1, section 2H, and section 173(8) of the Code of Criminal Procedure, as has been noticed herein above, and would be available at all stages of the progress of a criminal case before the trial actually commences. It would also be in the interest of justice that this power would be exercised sumoto by the magistrate himself, depending on the facts of each case. Whether further investigation should or should not be ordered is within the discretion of the learned magistrate, who will exercise such discretion on the facts of each case and in accordance with law. If, for example, fresh facts come to light, which would lead to inculpating or exculpating certain persons, arriving at the truth and doing substantial justice in the criminal cases are more important than avoiding further delay being caused in concluding the criminal proceeding, as was held in Hassan by Vili by Qureshi Supra. Therefore, to the extent that the judgment in Arup by Sambu by Patel Supra, Atul Rao Supra, and Bikash Rajan Raut Supra have held to the contrary, they stand overruled. Needless to add, Randir Singh Rana versus State Delhi Administration, so and Gita Nath versus State of West Bengal and others, 2009, so also stands overruled. As such, this court finds this a fit case to be sent for further investigation. Send back the CD to the IO. However, considering the time span of the investigation, the IO is directed to appear and submit a progress report of the case on the next date, Lordship. Then that is the observation of the case.
And I'm handing over, the citation is with me. And there's those words, if fresh facts to come for like.
Let him come.
Oh, it's not complete. Sorry.
Fresh facts, that is not in 173(8), but in the ruling of Supreme Court. Yes.
Sorry.
Yes, Mr. Amgar.
Lordship,
On what grounds fresh investigation was directed? Power is there. He has justified that.
Lordship.
Because of this ruling, I have the power.
Lordship.
But why he felt it justified to direct further investigation when there was a compromise between the parties?
But Lordship, those things were not raised here in petition, Lordship.
No, it was not raised, but
And,
we can.
and Lordship also, now the compromise is only one of the accused, not two accused.
Yes, that is a question.
Yes.
Because compounding may be against only one accused.
Yes.
So who has approached this court now? Both the accused.
One of them.
Against whom there is a compromise.
Minors, yes.
Okay.
And on the strength of that, that was not also leading, even in the additional reading, nothing was cited about the directive of this court when additional petition was also.
Whether there was a direction from this court to.
Kindly peruse those orders passed by this honorable.
No, you have to point out.
It will take some time.
Or you have to mention it. You have not mentioned it in your evidence on an additional affidavit that by virtue of this so and so direction, you are.
And Lordship, also the charge sheet at page 15. There is also say at page 15, my lord.
Page 58.
15, 15.
15.
Yes.
What it says?
It says further 5 mobile phones belonging to the accused Imti Onenla, the present petitioner, accused Palzer, and 2 witnesses Ms. So and so were also seized and forwarded to Commissioner of Police, Dimapur, for extraction of deleted data at NIE LIT Kohima, and result is still awaited. The charge sheet will be supplemented as and when the report is received.
Okay, that deleted data has yet to be.
Yes, this also yet to be submitted, Lordship. This is the situation. So even though observation was made by the learned magistrate below that, at page 20, my learned friend has pointed out that there would be no material to exhibit with the charge sheet or proof at the stage of it, and the trial would be only a few exercising futility. That is the observation. That is what my learned friend has pointed out, but still things are still coming out. So in fact, during trial, if this is the case, it will just help their cases only. But at this stage, just watch the proceedings below may be not in the interest of justice, as far as this order is concerned. In view of the Supreme Court order, which Madam Mayor knows better.
Okay.
The Vinubhai judgment I'm giving out.
Which was referred to by the magistrate.
Yes, my lord, yes. The very line when magistrate Lordship will kindly, I have taken the liberty, just my copy, I just pointed out with some pencil.
No.
So I'll see in the paragraph. Magistrate order, there is no issue. Premises are set. Is said if, for example, fresh facts come to light, under which condition he can go? He can order.
Here there are seized mobiles.
My lord.
Where you have deleted,
Yes.
it is alleged that you have deleted. So there was an attempt to extract the deleted material.
My lord.
And there is a.
That I admit. And apart from that, my lord, see 156 CRPC. 156, my lord, 8 chapter is, my lord, police officers' power to investigate cognizable case. And he has resorted to 156.3. 156 starts with 156.1, my lord. Any officer in charge of police station may, without the order of a magistrate.
Who has resorted 156?
My lord, 156, he has justified his order and taken recourse to 156. The London magistrate, 156.1 and 153.
Where?
I will see that order sheet. Coming back to my petition. And that Vinubhai also, my lord, it speaks about 156. But you will see page 23. Page 23, my lords, that order has been quoted, the Supreme Court ruling has been quoted, but it also speaks of 153 and 151. 156.1.
No, 156 is not at issue in this case. In this case, 173.8.
8, my lords. But 150 is 178 he's drawing. But my lord, it has to come from it has to flow from 156. In my humble submission, I may be wrong, my lord, I may stand corrected also. So my lord, this premises are set. When fresh facts come to light, where are those fresh facts? And my lord is my lord knows, my lord, that when the two views are possible. Two views are possible, my lord, magistrate ought to have resorted to, and that's line, my lord, even hypothetically, if you proceed, my lord. He orders a further investigation, or he gives time to the investigating authorities that you place on record the mobile data, or that has been a different area of, my lord, traversing, my lord. That's a different issue altogether. Now here in the magistrate says, even if you proceed in this direction, there are no materials and trial will be ending in futility. That is one. I conclude, my lords. That's just my limited submission.
I heard Mr. D. Gogoi, learned counsel for the petitioner. Also heard Mr. KV Angami, learned public prosecutor. Hearing concluded, judgment reserved.
For admission item number 10.
This, Albert, this you have to give in chamber. After arranging everything. Yes, Miss. Item number 10,
Yes, madam.
leave petition.
Yes. Lordship here, despite disclosing a cognizable offense, no investigation has been conducted. The FIR was also not registered promptly, Lordship. Several men attacked the petitioner while he was sleeping at one of his relatives' place at about 10 to 10:30.
Just a minute, let me compare the petition. Why this has been registered as leave petition instead of criminal petition?
Lordship,
No, I don't know, therefore I am asking.
yes.
This is a
Earlier,
petition
yes.
under 482
Yes.
for directing the state respondents to register an FIR and to investigate.
Yes, madam. Now, after I filed the instant petition, Lordship, the state respondents, they have come with the affidavit that my FIR has already been actually registered. After-
Had registered,
Yes,
had been
Lordship.
registered.
Yes, yes.
Then,
In the affidavit, that.
then this becomes infructuous.
No, my lord, no, no, no. I will explain the circumstances.
Okay, okay. No, but the nomenclature,
Yes.
why it has been registered as,
Lordship, yes, there is no clear-cut demarcation as to whether one should file under criminal petition or criminal leave petition when
There-
approaching this honorable court under 482, Lordship.
no, this is an application under 482.
Lordship. So it ought to have a criminal petition.
I don't know, I am just putting query to you. You have to answer that query,
Yeah,
either now or later on.
my lord.
This is, you can answer this query.
Yes.
Why this has been Mr. Jamir and Mr. Angami. Why this petition has been, what leave has been sought for? Why this has been registered as criminal leave petition? Why not criminal petition?
Yes.
I am not giving any opinion whether it is right or wrong. I just want to know.
Yes, Lordship.
You have to help me out later on.
That's it.
Okay. Yes, now proceed. This is ready for final disposal.
Yes, yes, Lord. Yes, yes.
Now,
There are private respondents who are
Yes.
contesting your,
yes, Lordship. It has been completed, affidavit has been filed, placing on report on 23rd of February this year, Lordship. Since you are not interested to appear.
okay. Who is contesting? 4 is contesting.
Yes, Lordship.
Only 4 is contesting. Okay. Yes, please.
In fact, 2 and 3 have also filed their affidavit. That is the SP Mochong and the officer in charge, police station 2, Mochong.
For them, Mr. Angami is there. Yes.
Now, Lordship, the petitioner, he is a native of Chongga village, which is under Mochong district.
Okay.
He has his entire family, his roots at Chongga village. And he is a police, Nagaland police personnel. So,
Chungkia
For some-
village at Mokokchung.
yes, my lord.
Okay.
The private respondents are also all from Chongga village.
Okay.
So last year, in the month of July, Lordship,
Petitioner is a police officer.
yes, Lordship, in the rank of Havildar at second NAP battalion, Alijan Mochong.
Okay.
So last year, in the month of July, he decided to pay a visit to his village. And he put up at one of his relatives' place. And he slept, Lordship. Then at about 10:30 to 11 PM, some people came around, a mob came of youths.
Okay.
And they came into the house, they entered the house and they beat him
On which date?
on 9th of July, on the night of 9 July 2022. At about 10:30 to 11 PM.
Okay.
He was beaten black and blue, Lordship. And from those mob, Lordship, he could identify from their voice, from the features, around 5 of them, Lordship. So he mentioned those people's name in the, those persons' name in the FIR, which he promptly lodged the very next day, Lordship, because the nearest police station is about 15 to 20 kilometers away from his village. The police station is at, the nearest police station is at Mahupsong town, Lordship. Police station 2.
So on 10th, he lodges an
Yes,
FIR.
yes. That is the very next day.
Okay.
Now the FIR, Lordship, I have annexed. The type copy is at page 20, wherein I have narrated the circumstances, Lordship, that 20 or 30% scam, and then out of that, some people I have named whom I could recognize.
Yes.
Now, despite the lapse of time, Lordship, the FIR was not registered. My FIR, Lordship. Which is why I again made an application before the SP Mahupsong, that is the respondent number 2 here. I filed my FIR before the respondent number 3. When he did not take any action, I filed further application before the respondent number 2, that is the SP Mahupsong.
Yes, SP when
On 26, that is after a lapse of 15 days, 26/7/2022, Lordship.
yes.
On the subject, an application under section 154, subclause 3 of the CRPC for investigation of the above referred case. So accordingly, it was filed. Now, my lord, even after that, no investigation was conducted, Lordship. So, and in the meantime, the respondent number 4, that is the village council, the Chongja village council, they wrote a letter to me directing me to withdraw the FIR.
Okay.
Which I have annexed at Annex 5A, Lordship.
Page.
Page 23. The translated type copy is at page 24. The first letter was served to me on 27th of July 2022.
directing me to withdraw the FIR, which I have lodged before the police station 2, Mokchong, by 2nd of August 2022. They also gave me a deadline.
When this letter was, this direction was given,
This direction was given
29/7.
27/7/2022, Lordship. That means I was given 5 or 6 days, about 5 or 6 days to withdraw me the FIR that I have filed.
That is the day after you approached the SP.
Yes, Lordship.
Okay.
Now, again, when I did not withdraw, Lordship, again, another letter was served to me on 29th of July 2022, stating that the withdrawal letter should be submitted to the village council.
Okay.
Now, my lord, I may be allowed to explain the circumstances why this village council, Lordship, have written this letter to me.
Yes.
The village, the Chongja village, they have adopted a resolution that in the coming general election, state general elections, the village, the entire village will support one consensus candidate. And that anyone going against it shall be punished by the village.
Okay.
So, the consensus candidate selected was one Mr. Tushikaba.
Yes.
Perhaps the village council, perhaps they were apprehensive that I had come in support of another candidate, Lordship. So, when the general elections was contested this year, Lordship, in the month of February, 4 candidates contested, Lordship, and then out of that 4, 2 was from Chongda village. Both of them were the unreturned candidate. Both of them were defeated candidate. Those 2 candidates from Chongda village. So
Those 2 were defeated.
yes,
Okay.
because 4 contested, the other 2 were from different villages. So one of the other candidates won. Now, the other candidate, Lordship, from the same village had to approach his honorable court, Lordship, challenging the decision passed by the village council that they will support only, the entire village will support only a particular candidate.
Okay.
And when the writ petition was filed before this honorable court, I have also annexed the order. The resolution was withdrawn, Lordship, and that is how the writ petition was disposed. So, like I said, Lordship, the villagers perhaps, and the village council also, on the other hand, they thought that I was not supporting the consensus candidate, Lordship, selected by the village, Lordship.
You suspect that for that reason you were attacked.
Yes, Lordship.
Okay.
Now, Lordship, this is particularly in my district, because I am also from that district, Lordship. Not a practice which is to be proud of, Lordship, but particularly in my district, Lordship, various incidents of election-related violence occurs. So, but despite that, Lordship, this was much before the election in the month of July.
6 months ago.
Yes, Lordship. Now, after I approached this court, Lordship, the state respondents 2 and 3 filed one affidavit stating that my FIR has already been registered on 12th of
July 2022. I have filed on 10 and they are saying that my FIR has been registered on 12 as GT3/2022/22 Lordship. And that Lordship, there was another counter FIR against me. That is yes, filed by some youths from my village. Which is why, Lordship, the contention in the affidavit is that they had to make some inquiry as to whether any cognizable offense has actually been committed by either me or by the persons who filed the counter FIR. Lordship. Now,
When this counter FIR was filed, on which date?
it was filed on 12th, Lordship.
Yours was filed on
10th.
10th.
Yes, Lordship. Now, Lordship, it appears that the police work in connivance with the persons who filed the counter FIR and the accused persons that I've mentioned in the instant case. Because it appears that, Lordship, they got the information that one FIR has been lodged against you, and then perhaps the police gave some advice, they wised up, and the counter FIR was filed. But in that counter FIR, Lordship, no cognizable offense has been disclosed. Whereas in my case, Lordship, I have been hurt, I have been beaten, there is lurking house trespass at night for committing an offense punishable with imprisonment. There is criminal intimidation. But despite that, Lordship, and Lordship, there is also an advisory issued by the central government to all the chief secretaries of the states in India, which I have also annexed, that when a cognizable offense is disclosed, FIR must be promptly registered. That is over and above the Lalita Kumari decision, Lordship. Now,
After Lalita Kumari, this
advisory was issued.
yes.
The advisory I have annexed at Annex 6, page 27, Lordship. It was issued on 12th of October 2015, whereas Lalita Kumari is 2014 judgment.
Yes.
Now, the state respondents, they have also come with the counter that medical stays was conducted upon me, Lordship, and that no injury was found on my body, Lordship. But the document that they have annexed, Lordship, it is only sugar test. Now, whether I have been beaten or not, Lordship, can that be found out by conducting a sugar test, Lordship? And
Sugar test.
yes, Lordship. And the interior chest view, Lordship, which is mentioned in the document that they have annexed, but the chest view, Lordship, it has not been annexed, Lordship. And then, Lordship, the doctor has prescribed for Signoflam TH8, Lordship, for 10 days. That, Lordship, is a painkiller, and which is consumed to deflame, Lordship, that is decrease inflammation on the muscles, joints, and the body. Now, the photograph, Lordship, that I have taken after I have been beaten up, Lordship, I have also annexed at page 24 to my affidavit in reply to the affidavit in opposition filed by the respondents 2 and 3. At page 24, annex 12, Lordship.
page 24 and exit 12. This is my behind, Lordship. The back view of my back. Can be seen that I have configured black and blue. Lordship, yes, that last page. This photograph was taken a few days after Lordship. I was beaten. Whereas in their statement, they have categorically stated that.
No, after lodging of FIR,
Yes.
whether you were medically examined by the doctor, whether the IO took steps for
No, nothing
your
of that
medicals.
sort, Lordship. After that is after 12, Lordship, the examination, Lordship.
Now, what is your grievance? They are stating that they
The
have
laboratory report dated 13/7/2022 has been annexed, Lordship,
by you.
by them, Lordship.
These are collected from you.
Yes, Lordship.
You have been subjected to medical examination
Yes,
on.
Lordship, yes, yes. But these copies, Lordship, I did not have it at my possession, Lordship. And then-
No, they have stated that they have registered an FIR.
Yes, Lordship.
So they are conducting the investigation.
They
No,
have not conducted the investigation, Lordship. That is the issue, Lordship.
that is the grievance.
Yes, and they have, without conducting investigation, in order to cover up the entire thing, Lordship, they have conducted a farce inquiry, Lordship, not investigation, Lordship. Now, inquiry and investigation are two different things, Lordship, under the criminal procedure.
Yes.
And my Lord,
The police station case has been registered or not?
yes, Lordship, as GD3 /
No, GD entry has been made. That is a different.
yes, Lordship. Only
Whether,
that, Lordship.
whether a PS case has been registered,
That, Lordship,
mentioning the offense under which,
no, Lordship.
in which the investigation has to be conducted.
No, nothing.
Okay.
Nothing, Lordship. Only that GD3, Lordship, /2023. Only that exists.
Apart from GD entry?
Nothing, nothing.
Okay.
To the best of my knowledge, my Lord.
Okay.
Now, Lordship, when the police protects the perpetrators of such brutality, of such violence, Lordship, and when the village council protects this kind of people, Lordship,
No PS case has been
no
registered.
PS case has been registered, to the best of my knowledge, except for the GD3 of 22. Now, Lordship, when such protection is given by the police and the village council, Lordship, who are supposed to be the custodian of my rights, of my personal safety, then a sense of invincibility, Lordship, comes to those perpetrators, Lordship. And Lordship, it finally culminated in the killing of one youth, Lordship, this year in the month of February. In my village, Lordship. One of the persons mentioned in the FIR that I have lodged on 10th is also one of the main accused, Lordship, in the killing of.
That is a separate
That
incident.
is a separate case, Lordship. But what I mean to say is, Lordship, if
That you are protected by police, therefore you are fearless. Though the
Yes,
perpetrators
yes,
are
yes,
fearless,
Lordship, yes,
they
Lordship.
continue to
Yes.
perpetrate.
yes, Lordship, yes. And perhaps if the police have taken action, acted on my FIR, Lordship, then that act may well have been prevented, either by deterrence, Lordship, or if they were under custody, then such things would not have happened. And Lordship, the persons, complainants number 1 and 2 in the counter FIR, Lordship, those 2 persons are also principal accused in that murder case, Lordship. They are, to the best of my knowledge, they are still under custody, Lordship, at District Jail Mogocho and under trial, Lordship. Now, having stated, Lordship, those facts, I may be allowed to kindly refer to the law laid down by the Honorable Supreme Court in Lalita Kumari's case, Lordship. I will refer only to a single paragraph, paragraph 120.
What is the citation of Lalita Kumari?
2014 to SCC 1, my lord. It is a 5 judges bench decision. That the bench led by then Chief Justice of India, B. Satasiva.
Yes, which paragraph you are referring?
Paragraph 120, my lord. The very last paragraph, page 61. Page 1.
Yes.
I may be allowed to wait.
Yes, yes.
Paragraph 120. In view of the aforesaid discussion, we hold 121. The registration of FIR is mandatory under section 154 of the code if the information discloses commission of a cognizable offense and no preliminary inquiry is permissible in such a situation. So, my lord, my case falls under this, lordship. Now, lordship, 122 is also important perhaps. If the information received does not disclose a cognizable offense, but indicates a necessity of an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offense is disclosed or not.
Okay.
(124), my lord. It says that the police officer cannot.
So your submission is in this case.
Yes, there is cognizable offense.
In spite of there being a cognizable offense mentioned in the FIR,
Yes,
they resorted to preliminary inquiry
yes,
after making a GT entry,
yes.
and
Lord.
thereafter they did not go any further.
Yes, Lord.
And the matter is still pending at that stage.
Yes, Lordship. Again, when we recent order passed on 8th of August 2022, my lord. Here they have referred to Lalita Kumari's paragraph 120, my lord, which I may not repeat. Page 3, lordship. The last, it's a very short order. The last page, lordship. In the instant case, the complaints submitted by the appellant to the concerned respondents did disclose the commission of a cognizable offense and also the names of the alleged offenders. In that view of the matter, we allow the present appeal and direct that the concerned authorities shall proceed further with the complaints filed by the appellant in accordance with law. Here also in my case, a cognizable offense has been disclosed and I have, lordship, named the alleged offenders in my FIR, lordship, whom I was able to recognize that night on which I was given. And the house was trespassed, lordship, at night. Lordship, whether a cognizable offense exists or not, lordship. Section 457. Lurking house trespass at night, lordship. Lurking house trespass or a house breaking by night in order to commit offense punishable with imprisonment. This is a non-cognizable. This is a cognizable offense, lordship.
Your submission is that FIR discloses an offense under
Yes.
section 457.
Yes. lordship.
Okay.
Yes, lordship.
And 457 and
457, 458,
okay.
506.
458,
Yes.
506.
Yes. These
and
are both 506 firstly and secondly, lordship, because 506 is part 1 and part 2, lordship. Now both are cognizable offenses, lordship. Now I am not mentioning the non-cognizable sections, lordship.
323 is also
Yes,
there.
lordship, but it is a non-cognizable section, lordship.
Oh, no, but if it is in
Yes.
addition to cognizable offenses,
Yes, lordship.
the case becomes cognizable
Yes,
case.
yes, exactly, my lordship is absolutely right.
We have to continue after lunch.
My lordship.
Yes, yes.
54.
54.
Yes. That we already The matter will be taken up, but I don't think our matter will reach the Lordship.
Unlikely.
Yes, Lordship, we would like to jointly mention the matter.
If it's taken up tomorrow,
54 when?
tomorrow.
Tomorrow there may be similar situation. I may fix it, but subject to it reaching. You want it tomorrow?
As the first item, Your Lordship,
No, that may not be,
after,
because there are other important matters. Today, also there are matters. Heard Miss S. Mere as well as
Mua Chungla,
Moa
Mua Chungla.
Chungla, Learned Counsel for S. Mere, Learned Public Prosecutor, as well as Miss Moa Chungla, Learned
here I'm
Counsel,
appearing as a government advocate, Your Lordship.
Government Advocate.
Yes.
On request of Learned Counsel for both the sides, let this matter be listed on after a week, listed in the next week. In the next week. We'll continue after lunch, your man.
No. I a criminal. Adjustment reserve done. Item number is that. Eight na. Okay. Yeah, bro, plus na.
From here. Yeah.
Yes.
Mm.
No, there's. Right now, two, three, four, five, six. Six matters. Yeah. There's six matters. No, I think number two is still going on. Ten is going on. After item number 10, I think I because so like to say that yes.
今度最低。착각도 아무래도 착각하네 끼웠어요 제가. 호이 꼬투대. 꼬투대. 호이. 아미 이제 좋아하시네. 그래 착각도 같이 되나? 이거네. 지. thế bây giờ anh bị số thế cái gì à ha hello à ठीक ठीक हुई ना अच्छा ओके होय अवेलेबल किंवा खुले ना अच्छा ठीक है ओके थैंक यू Hello, Kohima Ben, are we audible? Check. Are we audible? Kohima Benz, are we audible? Yes. Seconds.
Will Mr. Santiangan, how much time? We'll take up a fixed VC matter is there. Bail matter is there, short matter.
Okay.
After that, we'll continue with.
Oh,
you.
yes, yes.
Yes. Mr. Kaushik, whether case diary has arrived?
Case diary arrived, my lord.
What is your submission?
Not already, this matter was already rejected earlier. Am I audible?
Yes, yes, you are audible.
Yes, my lord, this matter has already been rejected earlier. Then now, the thing is that my lord, already 58 days. My lord. It is here.
What is the progress of investigation?
My lord, some of the witnesses were examined and sufficiently progressed, my lord.
Whether the charge sheet would be laid within these 2 days or it will take some time.
My lord, this CD is up to date till 20 September. After that, it seems, my lord, they have not recorded anything.
Neither they have laid the charge sheet. So because the counsel for the petitioner is praying for bail on the ground of lapse of time.
Lapse of time.
We allow him to go on bail.
Right.
Heard Mr. S.M. Mullah, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Irfan Sheikh alias Tepu, praying for allowing the present petitioner to go on bail who has been detained, praying for allowing the present petitioner who has been detained behind the bar since 15/8/2023, on bail. Stop. This is for the second time the present petitioner has moved this bail application when the earlier his earlier bail application was rejected on the grounds that there were materials against the present petitioner in the case diary. Today, the case diary which was called for has been placed before this court by Mr. R.R. Kaushik, learned additional public prosecutor, who submits that though there are materials against the present petitioner, however, the investigation has fairly progressed and the case involves offense for which the maximum statutory period of detention is 60 days and the petitioner has already undergone detention for last 58 days. Stop. Learned counsel for the petitioner has also prayed for allowing the petitioner to go on bail, mainly on the ground of period of detention already undergone by the present petitioner. Stop. Considering the submissions made by learned counsel for both the sides and considering the materials available on record, including the case diary of which
PS case number 229, public document.
Oralum of PS case number 299/2023.
229, my lord.
229/23. As well as progress made in the investigation. What What was the last name? Progress made in the investigation as well as the period of detention already undergone by the present petitioner. He is allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, Gauhati, subject to the following conditions: that he shall not directly or indirectly make any inducement, threat, or promise to any person who is acquainted with the facts of the case so as to dissuade such person from disclosing such facts to the investigating officer or to the court. He shall cooperate with the investigation. Any other condition?
Why not leave the jurisdiction?
Yes,
Not leave the jurisdiction of concern.
he shall not leave the jurisdiction of the learned Chief Judicial Magistrate, Kamrup Metro, without prior leave of the learned Chief Judicial Magistrate, Kamrup Metro. With above observation, this bail application is hereby disposed of. Send back the case. Albert. This has to be placed down, otherwise. Yes.
Your Lordship notices the mentioned item 26.
This has to be placed down, otherwise I cannot see the stenographer. Yes, Mr. Jamir.
Item 26, Lordship.
Item number 26.
And for the petitioner, Lordship. Notice of our respondent number 1 and 2 was issued on 9/3 and applicant status.
Voice is volume. The voice is not. Your microphone is on.
Yes.
Yes.
Lordship, notice summon R1 and 2 was issued on 2/9/23. And I've already taken the steps and it appears from the reports. So if it's not a notice, it's still awaited. So may I read that this man listed over 3 weeks?
Heard Mr. Wati Zamir, learned counsel for the petitioner who submits that notice on the respondent number 2 and 1 and 2 has, though notice on respondent number 1 and 2 has been issued. However, the service report is still awaited and therefore prays for listing this matter after 3 weeks. Await service report. Let this matter be listed after 3 weeks. Yes, should we take Mr. Moazamir or Mr. Senti Hanger? You are ready? Because if
For item number 1, if this honorable court allows, if this matter can be listed after a week, Lordship. In the meantime, I'll get instruction, Lordship.
okay, heard Mr. Moazamir, learned counsel for the petitioner who prays for listing this matter after a week so as to enable him to seek necessary instructions from the petitioner.
Lordship.
Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after a week.
Much obliged, Lordship.
Yes.
So, may it please, my lord. Lordship, I'll take only another 2 minutes, Lordship.
Only 2 minutes.
Yes,
Okay.
Lordship, now.
Let me see how long is your 2 minutes. How much time it takes to.
Lordship, after all those, Lordship, after all those incidents, the extra assistant commissioner Bangkok and executive magistrate, he adopted a process, Lordship, that resides under the criminal procedure code, Lordship. And after considering the, it seems, inquiry report submitted to him, Lordship, he arrived at the conclusion, Lordship, this is not a judicial order, Lordship. An order passed by an executive magistrate.
Which order?
Which it is found annexed at Annex 7, page 8, to the affidavit in opposition filed by the respondents 2 and 3. That is the state respondents, Lordship.
Next page.
Page 58. The type copy is at page 59. So on the stress of this order. Passed by the executive magistrate, Lordship, not judicial magistrate. The case was closed, Lordship, after making the 5 persons named in the FIR, those alleged accused persons, signed a bond to keep the peace for a period of 6 months. And in default, they had to forfeit a sum of rupees 10,000 rupees.
Police submitted a report
Yes,
under
Lordship.
107
Yes,
instead of registering a criminal case.
yes, Lordship.
Okay,
Now, when a cognizable offense is disclosed,
because this is in relation to a proceeding under section 107,
Yes,
this order.
Lordship, yes. Now, when a cognizable offense is disclosed, Lordship, there is a certain procedure already prescribed under the criminal procedure code, Lordship.
Yes.
Now that has not been followed. And this honorable court is aware that when a statute provides for a particular thing to be done in a particular manner, it has to be done in that manner. Now, coming back to Dalita Kumari's case, my lord, they have also referred to Pachan last case, Lord, of which judgment my lord is very well aware of that registration of FIR is mandatory and all those, Lordship, when a cognizable offense is disclosed. And Lordship, in paragraph 120.4, it is categorically provided that when cognizable offense is disclosed and when the police officer does not register the FIR, then action must be initiated against those during police officers. And certain class of cases have been provided under the same paragraph, Lordship, at paragraph 120.6, where preliminary investigation may be conducted.
120.
Preliminary inquiry, not investigation, Lordship, such as matrimonial disputes, commercial offenses, medical negligence cases, corruption cases, and cases where there is abnormal delay in filing the FIR. For example, over 3 months. Now, my case does not come under any of those categories, Lordship. That is,
You filed FIR on 10th.
yes, Lordship. And the incident happened on 10:30 or 11 at night, the day before, that is last night, Lordship. So within few hours, Lordship, I have approached the PS to Lordship. And that PS is 15 to 20 kilometers away from my village, Lordship. It is at Mohostung town, Lordship, whereas I am from Chongkar village. The incident happened at Chongkar village, Lordship.
Now this 59 has closed the,
Now, this is something, Lordship,
this is in relation to one.
this
Well-
is something that the state respondents have brought, Lordship, in their affidavit. I was unaware of all these things, Lordship.
Oh, this is the affidavit of SP Mokokchung.
Yes, Lordship.
Okay,
So, in other
now
words-
what is your submission?
In other words, Lordship, the respondents 2 and 3, they have tried their best to cover up the illegalities committed by the private respondents, whom I have named in the FIR. They have misused their position as public officers, as police officers, and at the cost of my personal liberty, at the cost of my fundamental rights.
Okay.
And that is all, Lordship. And I once again reiterate the law laid down by the 5 judges bench of the Honorable Supreme Court in Manila to my Lordship, that when the cognizable offence is disclosed, the FIR is meant.
So now what is your prayer?
That FIR may be registered, Lordship, and then investigation may be conducted and this necessary procedure under the law, Lordship, may be initiated.
Okay. Yes, Mr. Whether FIR was registered?
No, Lordship, on 10th, as FIR was lodged, and as my learned friend has already submitted, GDE was registered on 12/7/2022.
Seven.
2022, Lordship. 12/7/2022. 12/7/2022, GDE. Yeah.
GD entry number? GD entry was registered
yes.
on 12/7.
No, Lordship, GDE number 4/20/22 dated 12/7/2022, Lordship.
But he filed the FIR on 10th itself.
Yes, Lordship.
So there is a delay in lodging, making the GD entry also.
This is the record, Lordship. Then there was medically, he was also examined on 13th. As per the medically examined on 13th. 13/7/2022.
Yes.
Then 2 inquiry were conducted. First inquiry report was submitted on 17/7/2022.
Who conducted the inquiry and to whom it was submitted?
By the police, Lordship. Then again, second inquiry was conducted. A detailed report was submitted on 1/8/2022.
To whom it was submitted?
Firstly, the first one was submitted by the IO. Inquiry officer, inquiry officer, police station 2 Mokokchung, to the officer in charge, police station Mokokchung.
To the OC.
Yes.
Okay. Second one?
Second one is to the superintendent of police.
By whom?
By the inquiry officer again.
Okay.
Then to the findings of more or less, the finding of the 2 reports are more or less same. So Lordship, I'll to cut the time short, I'll take my lord to the second detailed report in the relevant portion.
At page
54, Lordship.
Of your affidavit.
Yes, my lord, my lord. Page 54.
But it starts
from page 48.
But relevant portion is at 54.
Lordship.
Yes.
Third paragraph, Lordship.
Yes.
Third paragraph. In the course of inquiry, the complainant stated in his FIR that some men numbering around 20 to 30 came to Mrs. Pangi Tsengla house widow while he was sitting along with his friends and beat him up and his friends without any rhyme or reason. But while recording his statement, Havildar Imkom Komzok, the petitioner lordship complainant, stated that around 10 of them entered inside the house and kicked him while he was sleeping and dragged him outside the house. While recording the statement, Havildar Imkom Komzok, petitioner lordship, also stated that none of his friends were beaten, harassed, except one of dire consequences if found indulging in political activities. The statement given by Havildar Imkom Komzok during the inquiry is found contrary with his written FIR. While recording the statement of Havildar Imkom Komzok on 14/7/2022 at PS2 Mokokchung, no external physical injury was noticed observed. The medical report, which was submitted by Havildar Imkom Komzok, dated 13/7/2022, doesn't mention any injury to his body. The next paragraph. No criminal cognizable case could be meted out during the thorough inquiry. Since there is a FIR lodged from both the parties, which with allegations and counter allegations, there is likelihood of breach of peace and tranquility in the village and within the villagers. Lordship, that is a finding. The next page is the medical report. Then because of this, there was allegations and counter allegations was there. The matter was forwarded to the executive magistrate under section 107 CRPC, Lordship. And then bond was executed, as my learned friend has already stated. So in the finding, no cognizable offense could be made out as per the FIR lordship filed by the complainant lordship. That is a report.
No, but FIR has to be registered once FIR discloses a cognizable offense. Later on, during investigation, if nothing is found, FIR may be submitted. Here the question is whether the FIR was registered or not. Here you are mentioning about the inquiry which is conducted prior to registration of the FIR.
So since there no as per the
inquiry,
there no cognizable offense.
Why inquiry was conducted?
Because complaint was FIR was lodged.
But in which cases inquiry is to be conducted, there is clear guideline in Lalita Kumari, where in which cases inquiry should be conducted, in which cases it is not left for the open to the police to decide. There are guidelines that in such cases inquiry may be conducted, and if it discloses an offense on that, what is your submission?
Lordship, that part.
Is it your submission that the FIR does not discloses any cognizable offense?
Lordship.
Is it also your submission?
Yes, that is my main submission. And
That FIR does not discloses? Or inquiry does not disclose?
Inquiry, Lordship. Inquiry. In pursuance to the FIR lodge, inquiry was conducted twice, Lordship. One inquiry, the other one's detailed report. No cognizable offense.
No, but the law, it appears that if FIR discloses cognizable offense, then unless it falls within certain category of cases, or unless there is a delay, or unless certain circumstances as already enumerated in Lalita Kumari, inquiry should not be conducted, FIR should be registered. What is your submission?
Lordship, that part, that aspect, I will leave it to my lord, but in support of my submission, allow me to place one authority.
Yes. What is this? Sakiri Basu?
Yes, Sakiri Basu, Lordship. 2008 to SEC 409, Lordship.
What it says?
Lordship, here the fact is the son of appellant was a major in the Indian Army, Lordship. His dead body was found on a particular day. Mathura police station investigated the matter and gave detailed report on particular day again, saying that it was due to an accident or suicide. Then the appellant was satisfied, and again because of his dissatisfaction, second court of inquiry was also conducted. Both come up with the same report that it was a case of accident or suicide. And in this regard, and then the matter went to Supreme Court, Lordship, and at paragraph 25, 26, 27, 28, Lordship.
Yes.
Paragraph 25. We have elaborated on the above matter because we often find that when someone has a grievance that his FIR has not been registered at the police station and or a proper investigation is not been done by the police, he rushes to the High Court to file a writ petition or a petition under Section 482 CRPC. We are of the opinion that the High Court should not encourage this practice and should ordinarily refuse to interfere in such matters and relegate the petitioner to his alternating remedy, first under Section 154(3) and Section 36 CRPC before the police officers concerned, and if that is of no avail, by approaching the magistrate concerned under Section 156(3). 26. If a person has a grievance that his FIR has not been registered by the police station, his first remedy is to approach the superintendent of police under Section 154(3) CRPC or other police officer referred to in Section 36 CRPC. If despite approaching the superintendent of police or the officer referred to in Section 36, his grievances still persist, then he can approach a magistrate under Section 156(3) CRPC instead of rushing to the High Court by a way of a writ petition or a petition under Section 482 CRPC. Moreover, he has a further remedy of filing a criminal complaint under Section 200 CRPC. Why then should writ petitions or Section 482 petitions be entertained when there are so many alternative remedies? 27. As we have already observed above, the magistrate has very wide powers to direct registration of an FIR and to ensure a proper investigation. And for this purpose, he can monitor the investigation to ensure that the investigation is done properly, though he cannot investigate himself. The High Court should discourage the practice of filing a writ petition or petition under Section 482 CRPC simply because a person has a grievance that his FIR has not been registered by the police, or after being registered, police investigation has not been done by the police. For this grievance, the remedy lies under Section 36 and 154(3) before the police officers concerned, and if that is not of no avail, under Section 156(3) CRPC before the magistrate, or by filing a criminal complaint under Section 200 CRPC, and not by filing a writ petition or a petition under Section 482 CRPC. It is true that alternative remedy is not an absolute bar to a writ petition, but it is equally well settled that if there is an alternative remedy, the High Court should not ordinarily interfere. So
okay. He should have gone to criminal court under 156(3).
Or filed under 200 CRPC. So,
but he has gone to superintendent of police.
That is number. So at this juncture, I think he still has remedy. So maybe I pray that this honorable should not interfere at this stage. That is my humble prayer.
Yes, Mr. Jamil.
Lordship, I'm agreeing for respondent 4. That is the village council.
Respondent number 4 is the
Village council. Village council. Village council.
Okay.
Writ petitioner as well as the respondent number 5 to 9. Here from respondent number 4 village. Lordship. Respondent number 4, that is the village council, has been undated because of the fact that the village council written a letter to the writ petitioner to withdraw the FIR lodge before the police. Lordship.
Yes.
And allegation has been made that the village council is protecting the respondents. Lordship, I made verification in my affidavit, Lordship, paragraph 6, paragraph 5. My affidavit, Lordship.
Yes.
Affidavit of respondent number 4, Lordship. Page 2, paragraph 5, Lordship. This may stand. May I read, Lordship?
Yes. Yes.
That with regard to the statements made in paragraph 6 of the petition, this document beg to state that on learning that there was some misunderstanding among the youth of the village on 9/7/22, the village council, an inquiry that is when it's certain that there was an FIR filed by the petitioner on 10/7/2022 against the respondent number 5, 6, 7, 8, and 9. It is also came to the knowledge of the village council that a counter FIR dated 10/7/2022 was also filed by then village youths against the writ petitioner for threatening one of the village council members and for breeding unpleasant environment in the village. Since the said misunderstanding occurred within the village jurisdiction among the villagers, resulting in filing the FIRs, the village council, in order to have a cordial and peaceful relationship among the villagers and to avoid unpleasant environments within the village, the present defendants on the capacity of the Chungdia Village Council should be written a letter dated 27/7/2022 and 29/7/2022 to the petitioner as well as to the then village youth who withdrew the respective FIR lodge before the police station. Do more. Such initiative taken by the village council and writing of the letters to both the parties to withdraw the respective FIR has been met with the sole object to maintain peaceful environment within the village and for the interest of the village in general. It is not that the village council directed the petitioner to withdraw the FIR, Lordship, but then use also a counter FIR were lodged against the writ petitioner. Therefore, the village council again written letter to those then village youths to withdraw the FIR. Therefore, the allegation that the village council, respondent number 4, is protecting the respondent number 5 to 9 is totally, Lordship, baseless. And so far as the registration
yes,
so far as the prayer for registration of the FIR and to conduct investigation, Lordship, the village council have no role in that.
no say. You intervened only because the matter was between villagers.
Lordship.
The petitioner is also from your village.
Yes. And the other FIR was also lodged by then youths against the petitioner from the same village.
Same village. Therefore, what you did? You
directed both the petitioner and the other then youths to withdraw the respective FIR.
So that they reach a settlement.
Lordship.
Okay. Mr. That Sakiri Vasu, what is your reply?
Lordship,
You could have approached, you can still go to criminal court.
Lordship,
Why you
The-
rush to high court?
Lordship, it happened like this, Lordship. The respondent number 4, he did not act in a fair manner, Lordship. In fact, Lordship, with the connivance of the respondents 2 and 3 and the respondent 4, the counter FIR was filed as a strategy, Lordship.
No, Lordship, it is on record.
And Lordship,
Submission should be based on record, Lordship.
No, but you,
It's a baseless
you
submission.
don't have any
and
grievance.
Lordship, in fact, Lordship, it is not the duty of the respondent number 4 to give ultimatums, Lordship, directions to whoever it is, whether it is the victim or whether it is the accused.
No, my query was different. Here your prayer is registration of FIR.
Yes, Lordship.
This same prayer you can make before the magistrate, who can issue a direction under 156 clause 3.
Yes, Lordship.
Then why have you approached this court?
Lordship, the existence of alternative remedy, Lordship, is not a bar for this honorable
But
court.
in Sakiri Vasu, the Supreme Court has said not to give indulgence to such
In fact, Lordship,
rushing of the.
in Prabhu Chawla versus State of Rajasthan, Lordship, the 3 judges bench of the Honorable Supreme Court, Lordship. I don't have the citation, the book with me right now, but if I may be allowed to submit.
What it says,
It says that Lordship, existence of alternative remedy shall not be a
not be a
bar
bar.
for the High Court to exercise its power under 482 of the Criminal Procedure Code, Lordship, because it starts with a non-obstantive clause that nothing shall prevent the High Court from exercising its inherent powers.
No, that Sakiri Vasu also says, it also does not puts an absolute bar.
Yes.
It also only says that High Court normally should not give indulgence. The language is.
But here, Lordship,
What is your submission regarding that?
here is a matter, Lordship, that goes to the very.
Should not ordinarily interfere.
Yes.
What
Here-
is ordinarily interfere?
Here is a unique case, Lordship, which goes to the root of the matter, Lordship. That, Lordship, when the police in connivance, Lordship, with the accused, works in such a manner so as to remove the accusations made upon the accused, Lordship, then the trust reposed by the public in the police, Lordship, is eroded. And as well as on the justice delivery system. Tomorrow, if such incident happens, Lordship, whom will the public approach? Should they fight amongst themselves, take up arms against one another?
No, but why did?
When?
No, my query is, I understand your submission.
My lord.
My query is, when when you approach before SP on 12th,
Yes, Lordship.
then you're.
Not on 12th, Lordship. After 15 days after I've lodged my FIR, on 26, I believe.
26th. But on 12th, they made a GD entry.
Yes.
Even after you're approaching the SP, the FIR was not registered.
No.
You could have approached the CJM Mokokchung.
Yes, Lordship.
Why you did not go there? Any justification?
Because, Lordship, I had a remedy to approach this honorable court under 482, Lordship. Of course, I could have approached under 156.3 before the magistrate's court, Lordship.
Because Sakiri Vasu has laid down law that
Yes.
normally you should go to the magistrate courts. Ordinarily, you should go there.
Yes.
And it is only otherwise that you have to seek remedy. High Court should have. How you overcome this hurdle? You just submit what is your answer to my query.
Lordship.
One submission is that existence of an alternative remedy.
Yes, Lordship. I could have approached this honorable court under 482, or I could have approached under 156 of clause 3 before the magistrate court. But I have approached this honorable court, Lordship. And this honorable court has powers under 482, Lordship, to consider my prayer. It is only a simple direction, Lordship.
Now that simple direction could have been given by the magistrate also.
Yes, Lordship. That is their Lordship. but I'm here. Lordship.
Okay. Anything?
No,
I'm reserving it.
my lord.
Heard Mr. Santi Anger, learned counsel for the petitioner. Also heard Mr. KV Angami, learned public prosecutor, and Mr. Wati Zamir, learned counsel representing respondent number 4. Hearing concluded, judgment reserved.
Lordship, if I may be allowed to submit Prabhu Chawla's decision.
Yes, yes.
To your yes, my lord. Deeply obliged, my lord.
For admission. Item number 30. Yes, Mr. Gauhati.
13, my lords, I'm on the questioning of a proceeding, GR proceedings, arising out of an FIR. This is a compoundable offense under 320. Informant is there, my lords. And we have also arrived at a compromise, which is annexed here, my lords.
Offenses are compoundable.
Compoundable.
Then why are you before this court? This could have been compounded before.
My lords, since, my lord, that when there's a remedy I sought here, my lord, since under instructions of the client to approach the High Court.
Clients may not be knowing. You have to guide your client properly.
What happened? This
Because
petitioner and informant.
the petitioner is inhabitant of which district?
Is from Assam.
As
He's from Lota Hill, Arnal Lota Hill PS. And my lord, this respondent is from my lord's Dimapur. So they were business partners. Some misunderstanding happened. Some.
This is item number
13. There was some exchange of some money. So there was some misunderstanding. FIR was lodged. In petitioner was sent to jail, released on bail. So my lords, after coming out, my lords, this money was returned. And there was an agreement.
during the pendency of this proceeding, compromise was or before filing.
No, before that, my lords.
Then
Before that, because I had approached with this compromise deal.
then best option, you have burdened your client.
Some factors are there, my lord. Since this person is from Gauhati.
Okay.
So.
And the respondent is in Dimapur.
Yes.
You could have approached Dimapur court.
So he chose not to come because, my lord, what had happened actually, very fair way, my lord. When he came, my lord, he was arrested and like put to jail. So there was some misunderstanding, so he doesn't want to come to Dimapur. He'll never set foot in Dimapur again. All this has happened.
This is a wrong.
No, this is wrong, but this is my instructions. That is the reason.
Yes, what is the submission?
Lordship, since the matter has been amicably settled, yes, all the financial obligations which was due to be paid to me has been paid. So, Your Honor, Lordship, I raise no objection.
Heard Mr. D. Gogoi, learned counsel for the petitioner. Also heard Miss
Vikali Aye.
Vikali
Aye.
Aye,
Yes,
learned counsel for respondent number 2, and Mr. V. Zimomi, learned public prosecutor representing the state of Nagaland. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely Ajaya Raja alias Romian Karunanithi, praying for quashing of proceeding in GR case number 416/2023, which is whether charge sheet has been laid.
No.
It is in investigation state.
My lord.
Under section
406 and 420.
under section 406/420 corresponding to Dimapur PS case number.
Dimapur East PS.
Dimapur East PS case number
0137 of 22.
013.
Page 31.
FIR is at page.
FIR is at page 28. 27 is the forwarding FIR. 28 is the
Corresponding to Dimapur East PS case number 137/2022. under section 406/420 of the Indian Penal Code. The said police station case was registered on the basis of an FIR lodged by Miss Lungjangin Lungnajing Sing Song before the officer in charge of East Police Station, Dimapur, inter alia alleging that the present petitioner, with whom he had some business transaction,
they entered into an agreement whereby informant agreed to invest certain amount of money.
business transaction, and who had entered into an agreement regarding investment of rupees 69,50,000 in the business of whose business?
His petitioner's business.
In the business of the present petitioner. And however, it is alleged that the said agreement was entered into only to misappropriate the money of invested by the present by the complaint by the first informant. Stop. Stop. It is submitted by learned counsel for the present petitioner that as the present petitioner and the respondent number 2 were having business transaction, due to some misunderstanding between them in course of their business dealings, the FIR was lodged. However, on 28th day of June 2022, they have reached into an amicable compromise amongst themselves. And in that respect, a compromise deed was also executed in between them. A copy of the said compromise deed is annexed along with the petition as Annexure E. Whether the compounding of case was a ground, it is mentioned.
There's a slide mentioned to it, that the case had.
Stop. Learned counsel for the petitioner has submitted that both the parties have amicably settled the issues between them, and the offenses involved in the case that is under section 406
and 420.
both are compoundable under
section 320 CRPC.
Both are compoundable offenses under section 320 of the Code of Criminal Procedure. It is also submitted that Ms. Vikali, learned counsel for the petition, learned counsel for respondent number 2 has also submitted that the respondent number 2 has no objection if the proceeding of Dimapur PS case number
137.
Dimapur East PS case number 137/2023 is quashed, as the respondent number 2 has compounded the offense, and after reaching amicable settlement with the petitioner. Stop. Mr. V. Zimomi also heard Mr. V. Zimomi, who does not have any objection if the parties reaches an amicable settlement, considering the fact that the offenses involved in this case are compoundable offenses. Considering the submissions made by learned counsel for the petitioners, as well as learned counsel for the respondents. And considering the fact of an amicable settlement reached between the parties with regard to the offenses, which are also compoundable offenses, the proceedings of GR case number 416/2022 correspond pending before the Court of London, Chief Judicial Magistrate Dimapur, corresponding to Dimapur East PS case number. You have not mentioned the PS
137 numbers
137
of 22.
of 22 are hereby quashed, and this criminal petition is accordingly disposed of.
For admission, item number 15. Yeah, please, Lordship.
Yes.
Lordship, I was arrested on the 3rd/6/2023 by the East Police Station, Dimapur, in connection with Simini Police Station FIR number 0014 of 2023.
Yes, there.
Lordship, dated 26/5/2023 and booked under 22C of the NDPS Act. Lordship, I was arrested.
Yes.
For the mere allegation that I have been selling 38 bottles of codeine to one of the alleged co-accused, Ishan Wankam. Lordship, herein, in this case, Your Lordship, I am a salesman, Lordship. I am a salesman at a chemist, Lordship. And here, Lordship, I work at K drug distributor located at S number B19 Crazy Complex, NL Road, Dimapur 79722. Your Lordship, the annexure is, I have appended the annexure as 3A. Page number 25, Lordship.
Yes.
Yes, Lordship. Also, Lordship, I am an employee at K Distributor Wholesale, bearing license number 644N, located at S number B19, Fraser Complex, Dimapur, Lordship. And the annexure is appended as 3B, Lordship. Page number 26, Lordship. Yes, Lordship. Lordship, if I may divert the court's attention to annexure 3C, Lordship. 3C, which is page 30, Lordship. I have a notification from the government of Nagaland, Department of Health and Family Welfare, Lordship. White order number HFW 22B 2001-47, dated 3rd February 2023, Lordship, wherein the permissible quantity of vial that I can sell is 5,000 bottles, Lordship, per month, Lordship. So, Lordship, here, Lordship, I am an employee, Lordship. I am an employee of a licensed chemist shop, Lordship. And Lordship, the allegation is I have sold 38 bottles of codeine to the co-accused Bishan Wankam on 29th and 30th of June, Lordship. Lordship, on the 29th, Lordship, on the 29th of May, Lordship. Sorry, on 29th and 30th of May, Lordship.
Yes, Lordship. So here, Lordship, on the 29th of May, where it is alleged by the investigating agency that I had sold 38 bottles, I was never here in Dimapur, Lordship. Whereas, Lordship, I was away with my newly wedded wife to Delhi, Lordship. And the flight tickets are annexed as Annexure 4A, Lordship. Page 34, Lordship.
Yes.
I was never here as alleged, Lordship. Only on the 30th, I was back to Dimapur, Lordship, from Delhi, Lordship. And then the train ticket is annexed as Annexure 4B, Lordship. Page number 36, Lordship.
What is your name?
Yes, Lordship.
What is the name of the petitioner?
Inaka Achumi, Lordship. He's a well-wisher of the accused, Lordship.
But train tickets are in.
Train tickets are in the name of Lipon, sorry, Lordship, Lipon Burman, Lordship. The accused name, Lipon Burman.
Okay.
Lipon Burman and Rimpi.
No, the name of the petitioner is Lipon.
Inoka Achumi.
But train tickets are not in his name.
Yes, Lordship, the petitioner, Lordship, is the well-wisher of the alleged accused, Lordship, since he's been the petitioner.
No, who is the accused?
The accused is Lipon Burman, Lordship.
Or Lipon Burman is the accused.
Yes, Lordship. So, Lordship, Mr. Lipon Burman, the alleged accused, and his wife, they were away in Delhi, Lordship, on the 29th of May, and come back to Dimapur only on the 30th, Lordship. The train tickets have also been annexed, Lordship, as an extra 4B.
Okay.
And Lordship, on the 30th of May, Lordship, I am not denying that I did not sell, Lordship. Yes, I did sell, Lordship, but on the 30th of May, I, as a licensed holder, had sold only 30 files of codeine, Lordship.
What is the allegation? How much you have sold?
38 bottles, wherein I had sold only 30 bottles, Lordship. Lordship, if the Lordship may come to
30 bottles?
30 bottles, Lordship.
In the pharmacy or?
Yes, in the pharmacy. I had sold it from the pharmacy, Lordship, after obtaining the certificates. And Lordship, the cash memo is also annexed as Annexure 3D. Page number 33, Lordship.
Yes.
Yes, Lordship. Also, Lordship, nothing was seized from my possession. All items were seized from the possession of the co-accused, Mr. Bishan Wankam, Lordship. There was no subsequent recovery for me, Lordship. And Lordship, the items were seized from Mr. Bishan Wankam on the 31st of May, 2023, Lordship. And it was sent for sampling only on the 5th of June, 2023, Lordship, after a delay of about 5 to 6 days, Lordship.
No, that does not help you now at this stage.
Yes, Lordship.
But for selling codeine,
Yes, Lordship.
whether prescription is required?
Lordship, I am a wholesaler, Lordship. I am a wholesaler. I was provided the certificate. Hence, as per the certificate, I had sold 30 bottles.
To anybody you can sell.
Lordship, to the registered license holders, Lordship.
So to whom you have sold?
I had sold it to Mr. Bishan Wankam, Lordship.
Who is also a registered license holder?
Yes, Lordship. He provided me the certificates. Hence, I had sold it to him, Lordship. 30 bottles. And I had annexed the cash memo as well, Lordship.
Okay.
Lordship, so Lordship, on this grounds, I am praying that I may be enlarged in bail, Lordship. Since nothing was seized from my possession, all items were seized from Mr. Bishan Wankam's possession. I am an employee of a registered license holder, and I had done all the verification before selling it to him, Lordship. I had even obtained the certificates, and I have annexed everything before this honorable court.
Which certificates you have obtained?
Lordship, I have annexed 3D, as I had mentioned, Lordship, the cash memo. And the investigating agency is alleging that I have obtained fake documents, Lordship. And there's no fake documents on records to prove otherwise, Lordship.
Yes, Mr. Anything else?
That's all.
Mr. Jumomi, is there anything?
Yes, my lord. Lordship, since the city is
I'll go through it, but what is your submission?
lordship. Here,
You want this case diary? Or
Lord.
this is a copy?
I would like to refer on the case diary, lordship. No, I have.
You have a copy?
Lordship, I
Okay,
have.
yes,
Lordship may come to the first page, lordship.
yes.
Here, it's a CD one, page one. Here, on 20, to the officer in charge, Simnu Police Station. Subject, so motors, sir, with reference to the subject cited above, I have the honor to state that on 25/5/2023, MVCP was conducted on National Highway 2 near Simnu Old Town Junction by Simnu PS. So,
What is MVCP?
Motor vehicle check.
Petroleum.
Lordship.
Okay.
So, during checking, 2,400 tablets of alprazolam were detected, which was sent as partial from the bus counter in Dimapur. Accordingly, it was seized by me under proposed seizure memo. The next page is, I therefore requested the esteemed authority to kindly register a case in this matter. On 25/5/23, the MVCP has conducted a national highway and in the national highway, and then they have intercepted one private night super bus. And from there, they have detected 2,400 tablets, lordship.
Okay.
So lordship may kindly come to, this is the FIR, so mobile FIR, and lordship may kindly come to page 2, CD2. Page 2, down in the bottom.
Yes.
Page CD2, page 2. CD2, page 2. It will be 1, 2, 3, 4. 4 page, on 4 page. If lordship have got CD2, page 2.
Yes.
Lordship. So lordship, here under statement was recorded under 161 CRPC, namely one Takotoshi Jamir, who was the sender, lordship. So his statement was recorded. So, and thereafter, one accused, namely Joel Mack, age 33, accused number 1. So I would like to read the relevant portion. Accused number 1, accused 1, Joel Mack. Lordship.
Yes.
Lordship. The second paragraph, he stated, this is a statement recorded under section 161 CRPC. He stated that he came to know I am the receiver through Toshi, since she is his girlfriend, elder sister. He also stated that the last month, that not remember, Ian came and asked whether she can get the medicine. So he gave her 4 box, 160 strips, 1,600 tablets of alprazolam. He stated that he used to take the medicine from a friend, namely Bishan Manipur of Half Nagarjan near our revival church, Dimapur. He said that he used to give money to Bishan and he goes out and bring the medicine, but does not know from where he bring the medicine. On 25/5/2023, he took the medicine from Bishan, containing 4 into 60 strips containing 2,400 tablets packed in the box, and give it to Toshi, the sender, to send it from the Tengsang bus counter, since Ian was asking since last week. He stated that on 26/5/2023, he was arrested by Dimapur police, and later on, Chimney police brought him to the Chimney police station. Lordship. Now, accused This is accused number one, Lordship. So I would like to come to the relevant CD, which is a CD4 page 1. Dated 31/5/2023. CD4 page 1. Has Lordship has got it?
Yes.
Lordship. This is accused number 3. In this connected case, Lordship. Accused number 3, I will read the relevant portion starting from 1, 2, 3, 4, 5 paragraphs.
Yes.
Now, self and party, along with his PS party led by UBSI John III, rush out for the said alleged accused person at Kuda village, half Nagarjan, Dimapur, during which he was formally arrested and search was conducted at his residence, accused number 3, and at his residence in the presence of available family member. During the search, 38 bottles of Toxovex plus codeine syrup was detected from his residence, which was also seized in the presence of his wife named Rushila Singh. Lordship, may kindly come to next page, Lordship. Note. Here is accused was interrogated on emergency at East Police Station, Dimapur, and recorded his statement as far from whom and where the seized alprazolam as well as the codeine syrup was purchased or supplied. During which he stated that he took the alprazolam from a person named Raja Bengali and the codeine syrup from a person named Lipon Baram, the present accused, Lipon Baram. Therefore, after medical examination at about 2,300 hours and a written requisition letter from 24 hours police safe custody was submitted at this police station for arrest of the said accused person. Requisition letter enclosed in separate, accordingly self and party held at Dimapur for the night. And Lordship may kindly come to the, now coming to the relevant paragraph, Lordship. CD7 page 1, Lordship. The present accused, Lordship. CD7 page 1, Lordship. Lordship has got it.
Yes.
Here, Lordship, accused number 4, the present accused, Lipon Baram, age 29 years. During the interrogation, the accused person stated as below. His name is so and so, so and so, so and so. Lordship may kindly come to next paragraph. Next page. The second paragraph.
Yes.
He stated that he started working in KA Drug Store, a wholesale medical store at KZK complex in first floor as salesman since August 2022. He stated that since being a wholesale, the store has the policy to provide the medicine only to the ones who are licensed. He also stated that he, along with Raja, gave the codeine syrup to Bisham twice. That is 30 bottles on 29/5/2023 and another 30 bottles on 30/5/2023 by obtaining a fact distributor certificate. Lordship. Here the accused under section 161 CRPC has made a statement saying that he has obtained a fact distributor certificate, Lordship. He is a salesman, the accused, the present accused, he is the salesman at the KA Drug Store, Lordship. So this is a statement. And now after interrogation, it is certain that Lipon Baram has given the say codeine cough syrup to Bishan. He is formally arrested in the presence of available witnesses, Lordship. Now, Lordship may kindly come to next page, CD8, page 1. The fourth paragraph. Note. Here it says, note, the contact number of Raja, the absconding accused person, was tracked from the cyber cell PHQ. However, the phone is still switched off and could not get the location, Lordship. As far as one accused, Raja, is concerned, Lordship, he has been absconded till that, Lordship. And his phone has been switched off, and the investigating agency could not locate the said accused, Lordship. And therefore, Lordship may kindly come to page CD9, page 1, Lordship. Fourth paragraph. May I read, Lordship?
Yes.
Now I forward the accused person Bishan Wakem and the present accused Lipon Baram to the Honorable Court and pray for 14 days judicial remand. The seized codeine syrup was also forwarded through Suminu PS Exhibit Challenge number so and so. Accordingly, drawal of sample was also conducted by the Honorable Court for expert opinion. Prayer for drawal of sample inventory and photo enclosed in separate. Lordship may kindly come to next paragraph, Lordship. Next page, Lordship. CD10, page 1. Second paragraph. Now I send the sample drawn by the Honorable Court to the office of the Senior SP Chimney for expert opinion from FSL. Now it has been sent to the FSL, Lordship, as far as the latest CD is concerned. Lordship, however, Lordship, here, if you go by the petition, bail petition filed by the petitioner, by the accused, Lordship, by the petitioner hearing, Lordship, on 2 occasions, they have approached the Special Judge NDPS Kohima, Lordship. If Lordship may kindly come to page 20 of the bail application, Lordship.
Yes.
The relevant, this is dated, order dated 19/6/2023. The relevant portion will be at page 21, Lordship. The third paragraph. Page 21, third paragraph, if I'm allowed to read, Lordship. Learned PP so and so submitted that the accused person has been arrested in the instant case where the present accused was arrested on 3/6/2023 from seizure of alphazeram and Terexis Toscorex plus codeine, which falls under the commercial quantity. There is a prima facie case against the accused in his 161 CRPC, the accused has stated to give the codeine syrup to Bishan twice by obtaining fake distributors certificate and objected to the release of the accused on bail. On going through the records along with the case diary, it is seen that the accused Lipong Barang has been arrested on 3/6/23 for offense under Section 22 NDPS Act along with 3 other co-accused persons. On 2 occasions, that is on 29/5/23 and 30/5/23, the accused has given codeine syrup to Bishan by obtaining fake distributor certificate, and accordingly, this bail application was rejected, Lordship. And subsequent to that, a subsequent bail application was filed on 24/7/2023, which is at page 22, Lordship. Page 22, and the relevant portion will be at page 23, Lordship. I will only read the last paragraph on going through, Lordship. Second paragraph, starting from. This will be relevant, Lordship. Page 23, second paragraph, Lordship. Starting from second paragraph. Learned so and so present for the state and submit that the accused has been arrested for offense under Section 22C of the NDPS Act with Section 34 IPC. The accused has sold the contraband cough syrup by obtaining fake distributor certificate to another co-accused, which lead to the registration of the incident case, which falls under CMPS. The learned prosecution also further submits that whether the procedure laid down under Section
Albert. NDPS. Yes. Yes, continue.
So procedure laid down under Section 52 and 52A of the NDPS Act are matters to be dealt with at the time of trial. Are the matters to be dealt with at the time of trial. She also further submits that there is a prima facie case against the accused of selling the contraband cough syrup and objected to the release of the accused person. The mandatory period of investigation is still not over, and to give enough opportunity to the investigating agency. Hearing both the parties at length, perused the entire report in hand along with the case diary. On going through the reports, it is seen that the present accused, Lipon Baram, has been arrested for offense under Section 22C of the NDPS Act, read with 34 IPC. One amongst the prayer of the Learned Counsel for releasing of the accused person on bail is for non-compliance of the procedure laid down by the law under Section 52 and 52A of the NDPS Act. The non-compliance of the procedure of Section 52 and 52A of the NDPS Act being matter of trial where evidence is to be adduced is not discussed at this stage. It is also further observed that the mandatory period of investigation is not over, for which this court is in line with the prosecution to give enough opportunity to the investigating agency for investigation. With the aforesaid mentioned, the prayer of the counsel to release the accused on bail stand rejected, Lordship. On two occasions, Lordship, the accused has approached the Special Judge NDPS Kohima, and on 19/6/2023, the bail was rejected, Lordship. And moreover, subsequent bail was filed on 24/7/2023, and that was also rejected, Lordship. So, Lordship, there is a prima facie against the accused.
From your Lordship. Lordship, the alleged accused, Mr. Lipon Barman, was arrested basing only on the sole confessional statement of the alleged accused, Lordship, while in custody. Lordship, it was basing on the confessional statement of the alleged accused, Mr. Bishan Wankam, while he was in custody, Lordship. Also, Lordship, pertaining to Section 52A, if Lordship may permit me to read, Lordship, the relevant portion. Lordship. 52A, disposal of seized narcotic drugs and psychotropic substances. Lordship, the relevant portion I will read, Lordship. Subpara 3, Lordship. Subclause 3, where an application is made under subsection 2, the magistrate shall, as soon as may be, allow the application. Lordship, I would like to rely on a citation by the Honorable Supreme Court on this, Lordship.
No, but okay. At this stage, we will have to see that embargo of Section 37.
Yes, Lordship.
Whether that comes into play or not.
Yes, Lordship.
You have to
Lordship.
jump the embargo of 37.
Lordship, in that case, Lordship, Section 37, Lordship, very clearly states that the prosecution has to be given an opportunity, Lordship. Also, Lordship, that the court should feel that I am innocent, Lordship. So, Lordship, in that case, Lordship, I am only a salesman. I am an employee of a registered wholesaler, Lordship. I work there, Lordship. I have my license, and I have produced before this court the cash memo as well, which I had sold it on the 30th, not on the 29th. 29th, I was never in Dimapur, Lordship. The tickets are in record, Lordship. I was in Delhi. I had come back only on 30th, Lordship. And I had sold 30 bottles.
He has not stated that when it was sold. It was recovered from the residence of that co-accused during a search operation.
Yes, Lordship.
And he stated that I purchased it from you.
Yes, Lordship. Which I sold it on the 30th. On the 30th of May, Lordship, not on the 29th. 29th, I was never here. The tickets are on record, Lordship. I was never here in Dimapur. It's a conflicting allegation, Lordship. I was away with my wife, whom I just married to.
Anything else?
Lordship,
what you wanted to show in 52A, this judgment?
52A, Lordship.
Tufan Singh's. Yes, Lordship. Mohanlal.
Yes, Lordship. Without undue delay, it should be sent for sampling, Lordship. Also, Lordship, the Honorable High Court, the Delhi High Court, just recently, Lordship, if the court may allow, Lordship.
No, but on that ground, whether 37 embargo can be overcome at this stage.
Lordship, in that case, Lordship, yes, I believe, Lordship, because procedure was not followed, Lordship. Article 21, Lordship, procedure established by law. NDPS is a stringent provision, Lordship, and strict provision must be followed. And the strict procedures were not followed, Lordship.
Okay.
Under Section 52A.
Okay. I'll pass orders tomorrow after going through the case. Heard Mr.
A. Nikato Watson.
A.
Nikato Watson.
A. Lika.
Nikato Watson.
Nikato
Watson.
Walsar, learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned public prosecutor. Let this case be fixed for delivery of orders on 13th of October 2023.
For admission, item number 17.
Keep this with.
Please, my lord. This is also an application under Section 49 of CRPC rate with 37, Section 37 of NDPS Act.
37.
Yes, Lordship. At the outset, Lordship, I have to clarify this particular point, Lordship. The offense was registered in the FIR. The offense was registered under Section 22B, subsection B, clause B.
22B.
Yes, but it has to be Section 21B, since the item seized was cough syrup containing codeine. So it does not come under psychotropic substances, but it comes under the category of manufactured drugs. That
Manufactured drugs.
yes, Lordship. So
Okay, let us call for the case diary.
Yes.
Case diary has, it is there.
Yes, Lordship.
Okay.
Yes.
How much cough syrup was?
Allegedly 85 bottles of cough syrup.
85
ml.
bottles.
Yes.
Then
100
it has to be 21C.
It has to be 21B because it does not, it is not a commercial quantity and it is not a small quantity. So
No, if it is 85 bottles.
Yes, Lordship.
Containing 100 ml per bottle.
Yes, Lordship.
Then it comes to.
It will come to 850 ml. Lordship.
850 ml.
Yes.
What is the commercial quantity?
1 kg. Lordship.
1 kg. Okay. How many days you are behind the bar?
As of today, 72 days. Lord.
Then what is the, if it is not commercial quantity, the statutory period of detention should have been 60 days only. Or is it 90 days?
Is it 90 days?
What is the punishment for 21B?
Beyond, maximum is 10 years. Maximum is 10 years.
Then it is 60 days, not 90 days. Mr. Angami, for intermediate quantity of codeine,
maybe extend to 10 years, Lordship.
may extend to up
10
to
years,
10
10
years.
years.
10 years is the maximum.
Yes, maximum.
Then it is 60 days. Or 90 days, my query.
That I have to clarify, my lord. I was of the impression that it is 90 days. I think it is 90 days. It is 90 days. Lordship.
You have to clarify them.
Yes, Lordship, I will clarify them. Allow me to just lay the facts of the case, my lord. It's just short,
21B.
21 Lordship.
Extend up to 10 years is not 90 days. That is my impression. You have to clarify that. Come up with clarifications on this query tomorrow morning.
Tomorrow morning, Lordship. I have difficulty tomorrow, Lordship. If that is the case, Monday.
Let it be on Monday. But my view is it is 60 days.
If that is
But,
the case, then
but,
it is.
but the petitioner himself is saying that 90 days. Therefore, I am confused.
Yes, Lordship.
You have to clarify it.
Yes, I'll make an endeavor to clarify on that point. 936, section 167. 2 plus 2. Yeah, Roman 1. 90 days. Where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years.
Yes, this has been clarified.
Yes,
Up to 10 years and not less than 10 years.
Okay.
There are judgments
Okay.
which have clarified that up to 10 years means 60 days.
Okay.
And not less than 10 years means has to be more than 10 years.
Okay.
And in up to 10 years, it can never be more than 10 years. So you have to make me understand again.
Okay, Lordship.
Then I will decide let it come up
Monday, Lordship.
on Monday. You look for the judgments, relevant judgments on 60, 90 days. This was item number
17, Lordship.
Mr. What is your name?
Toshio Longkumar.
Toshio Longkumar. Toshio Longkumar, learned counsel for the petitioner. Also heard Mr. KV Angami, learned public prosecutor, Nagaland. On request of learned counsel for the petitioner, this matter is fixed again on 16th of October 2020.
As a fixed item.
As a
Fixed item.
it will otherwise be fixed also.
Lordship, I leave it to you.
On which date the learned counsel shall clarify the queries posed by this court to the councils.
For admission, item number 28.
Please, Your Lordship. My lord, is a fresh petition. I've been advised that the copy of the claim has been received by the opposite party. They are yet to file they are yet to appoint the counsel.
But the service is yet to be reported.
Exactly, that's
Service is awaited.
agreed.
So we have to await for
My lord.
heard Mr. Elvil Zhao, learned counsel for the applicant. Stop. It appears on perusal of the office note dated 21/9/23 that the service report of the notices issued to the respondent number 1 is still awaited. Hence, let this matter be listed after 2 weeks. 2 weeks awaiting service report.
Right.
Yes.
for hearing item number 29.
Ultimately, it reached today. Actually, records have come.
Yes.
We already had a long hearing on this matter, and I have taken notes of the submissions made by both the councils on earlier occasions. Notes are with me. So fresh hearing, there are some queries. I just want to know one thing, that this interlocutory application where the prayer for additional evidence was made, that needs to be disposed of first. That I want to dispose it now, today, or I will fix tomorrow. I'll pass orders today or tomorrow. On that, I want your submissions.
So your lordship, if you take up on Monday, because tomorrow I have some personal.
No,
engagements.
are you ready today? Today, whether these submissions can be made?
What are the-
You are opposing their prayer.
Yes. So far as I'm concerned, I'm ready to.
Or on Monday also, because what I propose, because this is a very old pending case.
Yes,
Lot of litigations are there,
exactly.
and at a very late stage, they have come up with a prayer to exhibit a document purported to a letter of sale deed or something, what, I don't know,
Sale deed.
because.
Yes.
So can it be exhibited?
No. Because of the fact that on earlier occasions, at least 2 trials have been conducted. In both the trials, they have given the opportunity to exhibit any document, whatever they want,
Yes.
but they have failed to do it. That is one. Secondly, during the course of hearing in the earlier proceedings, the again and again said that we will produce, we have a sale deed, we'll produce that. That is many years back. As and when it is required. During the 2 trials, it was
No,
required.
suppose I'm just querying, I'm not giving any opinion.
Yes, Lordship.
Suppose it is allowed. Then what difficulty, because you will be getting opportunity to,
If it is
Cross-examine.
allowed, that will be contrary to the law laid down by the ethics court as well as the statutory provisions. The law do not permit to allow the parties to bring on record those documents after so many years without any justification. That too, on earlier occasions, I'm repeating, they have made categorical statement that we will furnish the sale deed as and when it is required. During the trial, they have not produced. Now, in the late of the day, when the appeal is filed, that too before this honorable court, before the high court, they want to exhibit some documents. Whether that can be allowed.
no, that is my query.
That is why there were 2 trials. In the earlier trials also, they have made submission. That was in 2005. We will place it. In 2018, the trial was conducted in Peg. That time also they have not produced.
They have stated that they could not locate the. They could not locate the.
That is why.
Yes.
Why they have not located, they should give satisfactory
Well,
explanation.
That
Why,
very,
as and how. In spite of their vigorous search, they could not get. Those statements has to be there. Those explanations were also not there.
okay.
Therefore, in any case, this application IA cannot be entertained at this stage. That is my submission. Law doesn't permit. And also there is a settled principle of law. In the late of the day, this cannot be. I will also place some citations as and when it is taken up. If I place those citations now, my learned friend will again come with new other plea. And this is an appellate stage, and Lordship is well aware, this appeal is filed under section 96 of CPC.
Lordship may kindly see the implication of section 96 clause 3. There are certain points which they have already admitted in their previous trials, because there has been a checkered history of litigation ranging up to 11 litigations, 9 litigations in the High Court and the 3 litigations.
No, suppose this is finally decided now. They will always have a feeling that we were not allowed to exhibit. I am not deciding. Suppose it is allowed, assuming it is allowed. You will always have opportunity of cross-examining to demolish that this was a fake document. But not allowing him may not give, would preclude him from bringing that document totally.
Lordship.
There may be good grounds for not allowing. I am not.
Yes.
I am not giving my judgment. It may be rejected or it may be allowed also. I don't know. I am just putting query that in the event of allowing that, to what extent you would be prejudiced, that I have to assess.
Yes, that is what the law also says. Let me express one thing, Lordship. Just because some of the parties have some wishes and desire and interest to do something else at any stage, just because they wanted to do something, whether that can be allowed. Therefore, ultimately, what the law says, what is the law, and that particular issue will be relevant. I'm on that. Just because they have filed an application in the late of the day, since they are asking something, something has to be done. That should not be the
No, not on that. Because after going through why I'm raising these issues now, because somewhere I am also confused to some extent, which you have to clarify. Both of you have to clarify. I raised queries on last occasion also that it appears that some procedural irregularities, whether it has caused prejudice or not, that has to be decided. But irregularities were committed by courts at different level.
Lordship, that will be taken care of by the probation itself, and I will make submission at the appropriate time.
Okay, regarding.
Yes, regarding that. There may be lapses here and there during the trial. On that point, there may be some technical lapses, technical irregularities, those things. Law will take care of all these problems, Lordship.
But you are not under any circumstances yielding to their prayer of allowing them to edit.
Yes. And one aspect, one thing is very sure.
Now, do you think that it would cause delay?
Definitely. That goes without saying. Another aspect.
The delay aspect, this court can take into care. What I propose, because on delay aspect, still I am not giving judgment. We are deliberating how to resolve the confusion which is there in my mind. Delay aspect, this court under the provision of CPC, this court can take evidence instead of sending it back, remanding it back. I can myself take evidence.
Lordship.
Then delay may not be caused.
Another aspect. What document you want to exhibit is sale deed of 1969.
Purportedly.
He came into the picture in the case, in the litigation.
84.
Yes, 84, 85. Whatever it is, that is up to 1969. And by bringing this sale deed between two persons, how will it improve their case? It will be of no consequence so far as I am concerned, because
yes. No, therefore I am.
Litigation was So that way, in no way I'll be prejudiced also, but why to waste time? When it is not going to have any impact. So again and again at the course of repetition, I'm submitting before the Honorable Court that this is nothing but a ploy to delay the proceedings because they are enjoying the rent on the suit land which they have constructed in violation of the High Court order.
Okay.
That is how they have been managing all these years to prolong. It's more than 45 years litigation now. And my client is more than 92 years now. Fortunately, still with good sense.
His client is still alive, whereas my.
No, I don't take
the
pride of
first-
this, but I'm
the first
just
plaintiff,
submitting
he has already
facts,
died.
the situation.
Now he's represented by his representative.
That is
legal
on record.
representative.
That is on record.
And if the inclusion of or allowing this application to
No, then,
exhibit this,
no, if there is no concession from Mr. Zamir, then we have to decide it strictly on law
there is
point,
the case.
law.
Yes.
I was thinking that if delay is not the cause of concern, if this court itself takes the additional evidence. The
Yes,
witness may be,
also.
a date may be fixed on the next week. Witness may be called for. And cross-examination may be done before this court itself, and then hearing and then judgment.
All those exercises have already been done. Cross-examination and that particular point has been done.
But
And
No,
it is on record.
not
It is on
this
record.
document.
I will show from record.
Not of this document. When the document is not exhibited.
no,
on the
no,
tribunal,
no, but then
there is
we
no
have to,
question of-
then we have to come to legally that what prevented you from,
The reason for not producing this before the court earlier, I have stated in my application. Now the court has to examine that one, whether it is right or wrong, and whether there will be the grounds given by the applicant in the application under Rule 41. Order 41, Rule 27, whether it will be permissible to allow this to be exhibited. Because there is no part, in fact, there is no part, but the court has a discretion whether to allow it or not to allow it. So it is up to.
no,
the
but
court.
there are legal principles,
Yes,
how to exercise the discretion
know
under
this.
4127.
that is the reason why reason has been given in the application. Why this should not be allowed. that is the
Can we
reason.
hear it now, the application?
Your Worship, in fact, I thought it would be for some sort of clarification. So in fact, I have not reviewed the petition as well as this application.
When,
So
and
if we can.
are you ready for final hearing? Final hearing means only
And
hearing
that application.
on that application
Yes.
and,
Tomorrow?
and some queries.
Yes.
Hearing has,
Lordship.
because
Yes.
this is a part heard matter.
Lordship.
Yes. Your Lordship, let it be
Exhaustively,
Monday.
it has been
Tomorrow
done.
I have some personal engagements, which I cannot avoid. So Monday will be over.
Okay.
What's the first item?
Let it be part.
Since it is a part
It is
heard.
not in the,
Monday,
Because normally on Monday, so many cases are listed. And today also it is item 29. But item reach at after 3:30 only. And my learned friend is
No, I
saying
am-
that he is not ready.
I was thinking that it would not at all reach the number of items listed. So now, what do you propose? Monday, I am ready for it. I am ready because still half an hour time is there.
I'm not ready, Your Lordship.
Okay, okay,
Yes,
okay. Because I need your assistance.
yes.
Tomorrow?
Tomorrow I have some personal difficulties. I cannot avoid.
Mr. Zamir is not yielding.
I'll be out of station from early morning.
So let it be on Monday
Your Lordship.
at a fixed time.
Lordship.
Let it be at 2. Or 2 would be, what would be convenient for you?
Two should be okay.
Tuesday.
So that part one matters can be done and
Yes.
then let it be fixed at 2 on Monday.
Yes.
That should be okay.
Heard Mr. L. Iralu, learned senior counsel.
Are yours.
Sorry. R. Iralu, learned senior counsel, assisted by Mr. Elivir Zhao, learned counsel for the applicant / appellant. Also heard Mr. C.T. Zamir, learned senior counsel, assisted by Mr. N. Long Kumar, learned counsel for the respondent. Let this matter be fixed for hearing on interlocutory application. Which one? There are the additional evidence matter,
84.
interlocutory application number
84
84,
of 2019.
84/2019. On 16th of October. 16th of October. 16 October we may. Do you have any? Sixteenth of October at 2 p.m.
Yours.
Let it be at 2 p.m.
Yes.
As a fixed.
As a fixed item, everything is
reflected as part heard.
as a part heard matter, as a part heard matter. Okay.
Oblige.
For unlisted motion, bail application 20 of 23.
Sir, Upadhyay was to move it, he fell sick, so I'm moving this.
Who
Mr.
was?
Upadhyay who mentioned, madam, in the morning hours,
Okay.
so he's not feeling well. Bill number 20, my lord. Order rejection is at page 22. The ground sold, no, not page 22, my lord, it's page 19 starts. At page 20, my lord, there's a ground for which it was rejected. The petitioners behind bars for 300 and more days. My lord. Arrested on my
300 and more days. What is
300 and more.
what is the
arrested.
offense?
Offense one is in custody since 9/12/22.
This is a charge sheeted case.
This charge sheet. This is our charge sheet.
Why the
This is East PS one.
the scan copy of the case record would be required?
Probably. No. Second also same, my lord. Item
Heard Mr. D. Gogoi, learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned public prosecutor. After hearing learned counsel for the parties, it appears that the scan copy, perusal of the scan copy of the what is the GR case?
GR case number, madam, item 20, GR case 363.
GR case number 363/2019 and the case scan copy of the case diary of Dimapur East PS case number
125.
125/2019 would be required for consideration of the instant bail application. Therefore, call for the scan copy of the aforesaid records. Fixing what date should? Mixed.
Any date which will be agreed.
$30.
30. So my colleagues will be there, 30.
30.
But otherwise, we are on holiday. Guwahati.
The vacation is up to 29.
But Guwahati is still like, still
Fifth.
4th.
So
My
fix-
colleagues are there.
Fixing 30 for scan copy of the records. In the next case,
Same, my lords, but PS case is different, GR is different.
in next case, same order,
GR case is page 17, 564.
GR case number 564/2022. Dimapur ESPS case number A187/2020.
My lords.
Others remaining same, fixing same date, 30.
My lords.
My please, your lordship. Lordship, I'm allowed to make one mention for argument, to be listed tomorrow. Argument matter.
Tomorrow, but it is too late. What matter?
Violation of, listed agreement. The respondent authority has entered another, listed agreement with the different entity. And they are, taken over by,
Because tomorrow we are having fixed matters.
by date 15. They are, having a joint inspection of the,
Okay, tomorrow at 2.
lordship. Highly obliged.
Okay.
This is 20.